for information regarding the status of each courtroom. The judicial branch has provided that. The judicial branch has also provided information regarding, I believe, rough cost estimates for each courtroom around the state. And the bill draft itself, there are no changes from the last meeting. With that, Mr. Chairman, I'm happy to answer any questions you have.
Okay, thank you. Any questions on the bill as proposed? All right, Rhonda.
Mr. Chairman, members of the committee, thank you. My name's Rhonda Munger. I'm the Deputy State Court Administrator for the Wyoming Supreme Court. I also serve as the staff member to court security, so I'm often involved in the security issues and questions for the state courts. At the last meeting, I believe it was Senator Hicks asked for some concrete idea about how much money we're talking and where cameras were located and those sorts of things. So I did a real unofficial, informal way of surveying the courts. I called each one of them and talked to the person, typically the clerk or the judicial assistant, and asked them about their camera system. And you'll see that in the first document. And then the second document, the cost analysis, this is just a real best guess scenario. And on page 2 of the cost analysis, you'll see the actual figures that our IT staff put together. Now, having said that, I would represent to you that we have many beautiful courthouses across the state, but they are not easy to retrofit technology to. And so this is probably just a really good beginning, because pulling wire through walls and sometimes needing electricians to come in, there are many hidden costs, I would assume. But with that, this was my attempt to comply with your request, and I'll stand for any additional questions.
Okay, thank you. Questions of Ms. Munger? Yes, Senator Anselmi.
Thank you, Mr. Chairman. Ms. Munger, when I look at this, I'm curious what full-time means. Are these cameras only in use, I guess, in the bill draft as well, when they monitor? Is it only during courtroom hours, 8 to 5?
Mr. Chairman, Senator Anselmi Dalton, that depends on the courthouse. And you'll see, I've tried to identify, and basically I just typed up what I was told. Some have full-time judicial, I would say, deputies in the courthouse during court proceedings. For example, in Judge Blumel's court, I understand they have a security officer in the building all day, but that security officer has to be split between circuit court and district court. They do have a camera system. Whether or not they're monitored full-time by the jail staff and those types of things, it depends on city to city or town to town. Does that answer your question? Not really. I can tell.
Is it 24? Follow-up, Chairman.
Go ahead.
Just are any of them 24 hours? I mean, is there someone monitoring these? Aren't these courtrooms closed down?
Mr. Chairman, Senator, the jail staff, right? So sometimes those camera systems, let me say it this way, sometimes those camera systems are hooked into the detention center. Mm-hmm. And if they are, then they are monitored 24 hours, right? But typically that is not the case. There is not a security officer in the courthouse typically 24 hours a day, nor are those cameras monitored 24 hours a day in most of our courthouses.
Any other questions? Point. Thank you.
Thank you, Mr. Chairman.
Okay, let's go ahead and open up for public comment with the state or county local agencies. Anybody would like to speak? Judge Day.
Thank you, Mr. Chairman, committee members. Just 2 quick points. I think the main thing that the district judges are concerned about is just making sure that we have the ability to monitor our courtrooms for several different purposes. We have many here, often we have many hearings a day. got to see who's in there, if the parties are ready, without having to just go peek through the window and stand outside until people are ready, and obviously see what's happening in the courtroom before we go in. We do have the supervisory duty when we enter the courtroom to try to make sure that things are, there's no unsafe situations, and we do that with the help of our bailiffs, but the judges have that kind of supervisory responsibility. So to be able to monitor that is extremely important. It would be great to have our staff, like our law clerks or staff attorneys, to be able to monitor that, as well as our administrative assistants, so that they can assist in that review. And doesn't matter to us who's responsible for that, or how it gets paid for, but it just seems it's a really critical part of our job to do that. The second point is just on subsection A on page 2, where there was the suggested revision to strike attend and put supervise. I just raise a potential issue there. I'm not sure what that really means, and if the county sheriff under that statute now has the ability to supervise courts of record, I could see some turf battles, and I think we don't need to do that. And I'm not sure that attend really is a problem there, because in subsection B, it talks about the sheriff being either physically present in the courtroom or monitoring that. But I think the different connotations of supervise there sets up a potential struggle that we could probably avoid. So those would be my 2 comments.
Okay.
Any questions?
Questions for Judge Day?
Thank you.
All right. From the county commissioners.
Morning, Mr. Chairman, members of the committee. Oh, you've secured this thing. All right. Pete Obermuller, Executive Director of the Wyoming County Commissioners Association. Rob Hendry, Natrona County Commissioner and President of the Association. I'm going to turn it over to Rob first for some opening comments, Mr. Chairman.
Hendry.
Mr. Chairman, Rob Hendry, Natrona County Commissioner and President of WCCA. We have some concerns about this, and you know, a lot of it boils down to money. I mean, we've got hiring freezes in a lot of the counties. A lot of the counties do not have the capability of this right now. And to get that way, we'd have to both get equipment and personnel. So we worry a little bit about that. Just speaking as from Natrona County, in your handout, the one that the cost analysis for Natrona County at 0. And I know that we would have to have monitors installed, and the wiring I think we've got pretty well, but we would have to have additional cameras. We've got a room that they can watch the halls, and they can watch the back of the courtroom, and it's pretty secure, but we do not watch the inside of the courtroom. When the IT changed over to the state IT, it used to be that the judges could watch from their offices and see their courtroom. But our system wasn't compatible with the state's IT, and so we lost that. In order to get that back, we just put a laptop in the back of the courtrooms, and the judges can see that, but they have to physically walk down and be right at the back door of their courtroom to look in. So that's the thing. We'd have to have additional screens in which to provide that. And so the 0 under Natrona County is going to be more. Then on the other handout, under the Natrona County side, you can see that the judges only have that. And the bottom of your new or the proposed legislation says that the sheriffs will monitor that also. So that's basically my comments, Mr. Chairman. We are not set up for it, and many of our counties are not set up for it.
So, Mr. Chairman, sorry.
Oh, go ahead.
Yeah, please.
Go ahead.
Thank you, Mr. Chairman. A few other points just to, I guess, amplify what President Hendry has just mentioned. As Ms. Munger said, that guess is just the best guess on the physical cost of cameras. We don't know whether that's true. We already think it's not true, at least in one county. But what that really misses is the cost of personnel. And that is going to be an extreme expense. The language on page 2 that the sheriff shall install, maintain, and monitor a closed circuit camera and television system for each district and circuit courtroom in the county means, essentially every time, all the time. And then if a county sheriff is a deputy not physically in a courtroom in his county shall monitor the courtroom using closed circuit camera. So whether or not you're physically present or not, there needs to be a person there all the time, every time. And while that's happening in some counties, it's not happening everywhere. And that's a personnel question. So, to the extent that the legislature has always been helpful to counties in terms of grants and those sorts of things, for the most part, those grants come with the restriction that we can't use those grants for personnel. So there's a disconnect here. And I guess what troubles us, Mr. Chairman, is we spent a year, we think this is important. These security is important. We think that IT is important, and we've had these debates with the judiciary branch on this on IT. In the case of IT, we sat in a room for a year and punched each other in the face till we came to an agreement on how we were going to do IT. In this case, we've had no opportunity to do that. We were not approached to try to come to any sort of agreement on it. So, with that in mind, Mr. Chairman, the fact that it is a pretty severe unfunded mandate, we would ask that you would table this bill until we have an opportunity to try to work out something more agreeable.
Questions? Yes.
Thank you,
Representative Salazar.
Thank you, Mr. Chairman. So I'm from Fremont. I know the state of the financial situation in my county. Bring it home to me. What does this mean if this bill were to go forward for my county or other counties with regard to what you're going to have to pay? Thank you, Mr. Chairman.
Mr. Chairman.
Yes, Mr. Obermueller.
Members of the committee, Representative Salazar, I don't know. That's part of the problem. I can't give you an answer about what it's going to cost Fremont County. I'm not sure that anybody knows. It's why I'm not sure that this bill is ready. We don't know what it's going to cost, but we do know that it's a pretty all-encompassing and restrictive mandate that. Part of me in looking at this in the spreadsheet about how things look in each county, it's interesting to see that part of me thinks that the bill is a little bit of a solution in search of a problem. We know that there are some problems, of course, and we can always do better and improve. But these negotiations are already happening in a lot of places. Some of the poorest counties actually says that there's no upgrades needed. So, the negotiation or the conversation between the judicial branch and the counties in these places is taking place and should take place. We're just concerned that rather than having that discussion happen with the elected commissioners in terms of how to prioritize their budget, would come here and put the thumb on the scale, that we can no longer have that conversation. We just must.
Representative Stiff.
Mr. Chairman, and this is a question for both of you, I guess. I understand the unfunded mandate argument with respect to the hardware, but I don't understand the argument with respect to personnel or manpower, because existing law already requires the sheriff to attend all courts of record in his county. And it seems like this bill actually reduces the manpower required, because you don't have to have a deputy sheriff stationed in the courtroom all the time. The sheriff's actually being relieved of that responsibility. And instead, you just have to have someone watching a screen who's also presumably doing other work as well. And I also don't see in here, since it's already been the law for 100 years, the sheriff had to attend I don't think the Supreme Court or anyone's ever suggested that existing law requires the deputy sheriff to be there at 3 o'clock in the morning for 7/365. And so I don't see that this change as altering that. Could you address?
Henry.
Mr. Chairman, Representative, a lot of times there'll be a sheriff inside the courtroom, but there's also one that's looking at, in Natrona County, there's one looking at the screens as well. And it's not just when court's in session. When the building's closed, and we have a separate courthouse, and when the building is closed, nobody's there. Even if there wasn't court going on, I heard from one of our judges today that there was a person in there getting ready for a court trial. And he just happened to walk by the back of the courtroom, not intending to go in, but saw on the screen that there was a person in there, and it looked like they might be harassing that person at the bench. And so we were not there. Now we got there because he called security and said, hey, you better get in there. But we weren't there at the time. And for Natrona County, yes, we have people. But in Hot Springs and in other counties, they don't have somebody there all the time.
Mr. Chairman, just a follow up on that. I mean, as the handout you have in front of you from the courts shows, there's not deputies there all the time. Personally, now, and you know, the question of attend, Representative Stith, is not the word attend is not defined. Doesn't mean, at least as I understand it, maybe Mr. Odekoven can help to clarify, but attend doesn't necessarily mean 100% attendance. In fact, on Campbell County, it says deputy present in courtroom when defendant in custody or upon request. I see that as quite a bit different from install, maintain, monitor even when not physically present. That pretty clearly to me and to us is a higher standard, and that's okay. We may get there. Again, I want to make clear that this is not. We think this is important, and we would like to work it out. Just not sure this is the bill that gets us there.
Yeah, Senator Hicks.
Yeah, Mr. Chairman, and Rhonda, I appreciate you putting that, because that's a starting point for a discussion. But you know, along those lines, not only looking at the initial cost, but I'm curious, is because we know with anything that involves technology now that it rapidly has a very short finite time frame. I'm curious, is again, not only looking at the initial equipment costs. I think the issue of additional personnel costs is something that we're going to have to get back from the county sheriff's department. That was another thing, but the annual operation and replacement, the maintenance and replacement costs. What's the frequency? You know, what's it cost to replace the whole system and one of the existing? So I think those are questions that need to be answered also. I just think there's a lot of questions on this side, and given that we've got some history here that did work really well. I mean, we went through this with the whole IT stuff.
Hi, it's Lisa. I am making a final attempt to reach you regarding your recently issued student loan pre-qualification. You are pre-approved for a lower monthly payment, as well as loan forgiveness. We have tried a number of times to reach you with
Chairman. Yeah, Mr. Chairman.
Problem solved.
I do also get those calls that you just got. Yeah.
We'd like the counties to help us with some
Yeah,
funding
yeah,
for
right.
our phone system.
Lower your interest.
Mr. Chairman, I do think that this would, what I'd like to see happen here is have county commissioners who control the budget, the sheriffs that are going to have to be in charge of actually providing the oversight and the personnel, and the courts get the judicial branch get together on this. I think it'll make a much better product on the back end, and we all understand the need. You know, we put money out there for court security. We take this serious, and we're going to continue to move this forward. But I just think at this point in time, there's a lot of unanswered questions with the bill.
Chairman,
Senator,
if I may, I just can't imagine too many higher priorities for a county commission than to make sure that the courts are secure. I mean, you're located in the courthouse. It's the center of the community. And I'm heartened by how many counties have actually undertaken to get this done. And in the larger scope of things, I would think that $10,000, $20,000, $30,000 in the budgets of some of these communities could be found. Now, there may be some that are just down to their last 2 nickels, in which case they might be able to work it out with the court. We might be able to give something to the court to help those counties most in need. But I think it's important to get this going. It took us way too long to get that last bill going. The infrastructure, the court infrastructure bill, it should not have taken that long. And I think the virtue of this bill is we put it out there as a mandate, and it creates pressure to get it done. Now, we got a session coming up. We're short on the budget, but we might be able to help out somewhere. So I wouldn't walk out of here feeling like it's a completely unfunded mandate. We might be able to get something to the court to help, but I think it's important that we get this underway. These courtrooms are, they've got a lot of bad characters cycling through them, and some of them are juiced up by drugs like we've never seen before in history. And I think it's just real important that we get this security going. I would not dismiss this as an unfunded mandate. I'd get this on. I'd get this moving, and keep the pressure on to get this done ASAP. That's my 2 cents.
Okay. Representative Pelkey.
Thank you, Mr. Chairman. I'm not 100% certain these are the appropriate people to ask, but I'm looking at these numbers. They seem extraordinarily high. I mean, we put in a camera system in our new building for $1,000. It's quite easy to monitor. There's no, I mean, I'm wondering, and as Senator Hicks alluded, a lot of times these new technologies are obsolete within a few years. However, if you recall, their obsolescence is also followed by cheaper replacements. I mean, we're putting in computers that are 1,000 times more powerful than they were 20 years ago, and they cost in the hundreds as opposed to the high thousands. And I'm just curious, cameras technology is improving to the point where it's quite affordable. And I'm wondering why we're looking at numbers that go upwards of $33,000 and $16,000 when we in the private sector are doing it for considerably less than that.
Mr. Chairman.
Yes.
Representative Pelkey, it's a great question. We didn't put together those numbers. We're seeing those at the same time you're seeing those. So that's part of the question about the bill. Don't know what those numbers necessarily mean. So we'd have to look at that. I don't think that you're necessarily wrong. And to Senator Kinski's point, I think his argument is exactly my argument. You look at the 3 poorest counties in the state, they've already worked with Judiciary to get this done, which shows that it's a priority already. So I'm not sure of the necessity of the bill because of that.
Mr. Chairman.
Yes.
Representative Pelkey, I talked to my sheriff, and our courtroom or our courthouse is completely separate from the old courthouse where our offices are. So it's a completely secure facility.
Yeah.
But we're having some problems, some glitches in our system that is now 10 to 12 years old. He got an estimate to put a whole new system in there, and it was $150,000 to $200,000 in Natrona County. That's what he just told me yesterday. And of course, we did not bid it out yet, but that's what his expert he talked to thought it might cost.
Mr. Chairman, if it does end up costing that, if you could call my office, I may have a bridge for you to buy too.
Senator Kinski.
Just to tag on this Representative Pelkey, the deputy in Sheridan does it all off an iPad. He circulates between circuit court and district court, and he's monitoring, switching amongst cameras. He's doing it on an iPad. It's a $600 iPad. I don't know where the $150,000 comes in, but it's out there. And I don't think these judges are asking for $150,000. They're just looking for something to help supplement the security there and make everybody feel a little bit more at ease. Thank you, Mr. Chairman.
Yes, Representative Pennell.
Mr. Chairman, thank you.
I don't know if it's a question or not, but I think that if you are, and we already have Sheriff's Association, those different groups that already get together, and along with the County Commissioners Association, I think it would be a good idea to get together on this and try to come up with a plan that would fit each individual county. Doesn't have to be a state plan; it just fit the county. The way I look at it, so I'm kind of in favor of what they're saying. Kind of hold off on this because I've always said all along I'm not going to pass or vote for a mandate to make the county pay additional funds when some of them don't have it. So.
Other questions? Mr. Overmuller, what happened or how's it worked out on that funding source we did for tech here last year in the bill and the collection, and any of that money coming through?
Mr. Chairman, actually, I can't answer that question. That might be, Ms. Sharp might have more details about how that rollout plan is going. I haven't heard complaints from the commissioners about it. So, which, usually for me, no news is good news. So.
Okay.
Mr. Chairman, in Natrona County, I think it went well. They came up and put the new system in. But as I said earlier, when they did that, then it took the ability of those cameras in the courtroom there wasn't the same technology. But I think it went well, but I don't know where the dollar figure is.
All right. Anything else from this committee? Thank you very much.
Thanks, Mr. Chairman.
Any other agencies? Yep. Please, Lily.
Mr. Chairman,
Yes, ma'am.
I just didn't want Pete Overmuller to ever get the last word. Just to update on the court technology funds and that increase in funds, those funds, and the Supreme Court has specifically advised the judges and the district court judges and the circuit court judges, we don't believe that those funds were allocated or appropriated for court security. Those funds we have been using and we will continue to use on upgrading the IT in the courtrooms. That is the presentation systems, the audio systems. And unfortunately, since there's been a decrease in the number of tickets and citations issued in circuit court, we are actually, we will be about $3 million short over during this biennium and the next biennium. So what we're having to do is, you all approved a rollout plan of the upgrades of the IT in courtrooms, the presentation system again, and just the hearing system, and so that there's hearing assist for individuals who are hard of hearing. The rollout plan has been changed because we don't have enough money to roll out all the IT in the courts over the next 7 years. So what the plan is now to just at least roll out an audio system in all of the courts. And the district court judges here can tell you much more about the need to actually have speakers. So that's where those funds are going.
Well, I just remember this. It's the exact same conversation we had 2 years ago, and we tried to provide a legislative remedy, and now we're having the same conversation again. And not that it isn't a valid conversation, but is there an end, or is there not an end, or is there just more and more of this county operations fall to the state?
So, Mr. Chairman, members of the committee, our position has been, and again, it is a question of money, is that when it comes to security under the statute that you're looking at, that it is the county's responsibility for security in the courtrooms, and we understand that it's a matter of money, but again, the judge can tell you, but the problem is we really are having incidents in courtrooms. There was an incident in Evanston was it? And then, so there are lots of incidents in the courtroom. And the problem with the judges is if they walk in to a courtroom where there's already, for example, there's already a melee and there's no deputy there, and there is no way for the actual sheriff's office to see. Even now, what happens is oftentimes then the judicial assistant or somebody in the judge's chambers has to have been monitoring the camera and then be able to call the sheriff very quickly. But again, I will let the judges answer more to the actual issues that they have.
Yes, Senator Kinski.
Before she goes, Ms. Sharp, I just, on page 2 of the bill, paragraph B, do you read that to say that the sheriff has to monitor those cameras 24/7, or are we talking about what is necessary in terms of monitoring? I would assume it's just when the court is in session or the courtroom's open to the public. If it's locked up, the courthouse is closed, you don't need those cameras monitored, do you?
Mr. Chairman, Senator Kinski, absolutely. It's only when the court is in session. And again, I would defer to the judges to, if I would assume, but again, I don't know, that the most important time is during criminal proceedings. But again, I'll let okay. I'm going to let the judges who actually know what's going on talk.
Leland.
Representative Stitt.
Mr. Chairman, Ms. Sharp, you mentioned that citation revenue is down. When we met in Laramie, we saw a lot of charts about between 2013 and 2018. Drug arrests along the I-80 corridor were up very substantially, 162% in Sweetwater County, or 72% in Sweetwater County, up 152% in Carbon County, up a similar amount in Albany County and Laramie County likewise. So it just surprises me to hear that we got all these extra arrests, at least in the drug offense category, going on. That was the present day. Marc Pelka did that. CSG, we had hours of charts and graphs and pictures and things about that. So I'm just surprised to hear that our citation revenue is down if all these extra arrests are happening. Do you have any comment about that?
Mr. Chairman,
Please.
Representative Stitt, it's the citations that are down. So and that is where the substantial amount of funds that come in to the courts is through the circuit courts. Not that, okay.
All right. Anything else? Ms. Sharp, thank you, Lily. All right, anybody from the government side? Anybody else? You want to speak on behalf of chiefs and sheriffs? The chiefs anyway, or sheriffs, excuse me. Mr. Odekoven?
Thank you, Mr. Chairman. Byron Odekoven, representing the Wyoming Sheriffs and Chiefs Association. The bill is of concern from the standpoint of the shalls. And of course, you've already heard from the county commissioners in terms of the cost, which is where the sheriffs would turn to for funding for the bill. But it says each sheriff shall do these things, which creates a significant burden or different proportionality to burden to the court, to the number of courts, to the sophistication of the offices. But suffice it to say that it would be received much better if the state were to fund that shall, but if it's left to the county budget, that's going to be very difficult at best. And as we've already alluded to, the funding necessary to have a staff person, a deputy, actually monitor that camera is significantly different than other forms of monitoring. I am not saying that monitoring of the court, cameras for the court, security for the court aren't necessary. This is more of a funding discussion of how best to accomplish that in light of the bill saying that we shall do these things.
Okay. Any questions? Thank you. All right, I think that covers the agencies. Public comment. Any public comment on this particular proposed bill? Thank you. Back to the committee. Committee?
Second.
Got a motion and a second. Any discussion on the bill?
Miss,
I want to get down to staff comment, Brian. Oops,
Mr. Chairman.
Representative Stith.
Thank you. I would propose an amendment to the bill to delete the phrase closed circuit wherever it appears on line 23, 25, and 29. The idea being that closed circuit implies a physical closed circuit, and that's not what you do anymore.
Motion and a second to remove closed circuit. Any discussion? All in favor, say aye.
Aye.
Opposed? Passes. Brian, you've got under staff comment. You want to talk about that at all, or we got it covered?
Mr. Chairman, especially in light of Judge Day's comments, the intent there was to avoid an incongruity between the word attend, which could very well be interpreted to mean physically present, and the requirement in B that if they're not physically present, they have to watch the cameras. Mr. Chairman, I would suggest that perhaps another word like monitor may be more agreeable. But certainly Judge Day's comments about supervising all courts of record could potentially be interpreted to mean supervise the court itself as opposed to the security in the courtroom.
Okay. Representative Olson, what word would you choose?
Wake up.
We're on line 5.
Teacher call.
Oh, always want to call on you.
I'm going to go with monitor.
Is that monitor for 10 or is that?
Oh, way to play teamwork.
Second.
Okay. We've got a motion. I'm going to call that a motion. Got a motion and a second for the replacement word instead of attend or supervise to be monitor. Discussion. All in favor, say aye.
Aye.
Opposed? Okay. All right. Yes.
I'd like to make another
Please.
amendment. And it'd be on page 2. I missed any of you pointed them out to me, but I would like to remove shall to may on line 22, on line 26, line 20, 28. I believe that's all of it, but unless I missed something, but I would like to amend that to take note.
Got a motion
Second.
and a second. One of the early criticisms I used when I tried to run a bill was if it's going to say may, do we really even need it? If it's optional, it's optional. Just to point out, you could easily strike that whole paragraph if that's your.
Mr. Chairman.
It's just a suggestion.
Well, yeah. No, I'm going to stick with me.
We've got a motion and a second. Discussion on the motion.
Mr. Chairman.
Yes.
On and against the amendment. Current law says the sheriff shall attend to court and shall provide security. This is just a logical extension of that. I see no reason to make it optional to monitor a camera system that's in the court system. They should welcome this as an opportunity. It extends the reach of the deputy that's assigned to court security, because they have these camera systems now. They can move around the courthouse with the iPad, and they can be simultaneously monitoring many courtrooms at once. I think we've got to keep it at shall. The current dictate to in statute, since we were a territory, is the sheriff shall provide the security. Thank you, Mr. Chairman.
Yes.
Thank you,
Representative
Mr.
Pennell.
They currently do. They do attend to the court. They do provide security. I think what we're doing here is also, it's not only for the sheriff, but it's for the local counties, a burden of financial responsibility, and we're not covering that. So I think that the majority of them that will provide that service of cameras and the right type. But I think we've heard testimony here earlier that they're, commissioners, they want to get together with the sheriff, with the court, to come up with responsible ideas. So I still think at this point, we're going to pass this bill. And I'm on the side, I'm against the bill. But if we're going to pass it, we should have it to where it can give them an opportunity to keep going.
Okay. Any other discussion on the motion to strike all shalls? Make them optional. All in favor, say aye.
Aye.
Opposed?
No.
No. Fails? Okay. All right. Any other amendments?
should just delete the enacting clause.
Other amendments on it? Any discussion, please? Yes, Senator Anselmi.
Mr. Chairman, on Part B, I have some pause about the not the legality, but the repercussions if something happens and they're not monitoring it, they've stepped away for a moment, can they be sued? For example, at our hotel, we were instructed not to put security cameras in our pools because then it implies that it's being monitored. If there's injury and accident to a judge or some person in there, two inmates get in a fisticuff brawl and one of them kills the other and they're not monitoring it. I just have concerns. So for that reason, my proposed amendment would be on line 27 to delete the last sentence, which starts with the county sheriff or his deputy, and all the way down to line 30 system, at least take out that piece of it and delete it entirely.
Delete from on line 27, a county for the remainder of the paragraph. Okay, 4 sentences, well, 3. Those 4 lines, the majority of 27. All right, is there a second?
Second.
A second by Representative Stith. Okay. Any discussion on the removal of the monitoring language? All in favor, say aye.
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 Opposed?
Show of hands.
Batteries must be dead in my hearing aid. I think the ayes has had it. Unless somebody wants to call for the question.
It was
We're gonna
like
have to
3
vote louder
votes.
than that. Call for the question. Hands in the air to remove that sentence. 1, 2, 3, 4, 5, 6. And opposed to the motion, hands in the air. 1, 2, 3, 4, 5, 6.
Kinski.
Chairman.
Dave. And I vote aye. So that comes out. We called it the Kinski Amendment. Okay, so now our bill essentially is page 2. We change supervise to monitor, or tend to supervise to monitor. And lines 22 through halfway through 27. Okay, and this is still shall. So it shall monitor and equip. Any other motions to amend? Okay, discussion on the bill before we go to the roll call vote. We ready?
Mr. Chairman, this would be a vote for the committee to sponsor 19LSO 25, working draft .5 as amended. Senator Anselmi Dalton?
No.
Senator Hicks?
No.
Senator Kinski?
Aye.
Senator Nethercott?
No.
Representative Beitman?
Aye.
Representative Jennings?
Aye.
Representative Olson?
Aye.
Representative Pelkey?
Aye.
Representative Pennell?
No.
Representative Salazar? No. Representative Stith?
Aye.
Representative Winters?
No.
Chairman Kirkbride?
No.
Chairman Christensen?
No.
Mr. Chairman, the motion fails by vote of the Senate. 1 aye, 4 noes.
All right.
Move on.
The only thing I'd say is, and this really to Pete and your organization, is this isn't going away. The issue is still there, the security, and in this society, sounds like we need to try to make time to flesh out a conversation that we can all agree on, the majority can agree on. And so I'd hope going forward that becomes people remember what happened today and take this on either as a individual bill, if there's time to address it, or I don't know that it requires committee interim work. There's already been a lot of information gathered, but kind of get it sorted out. Just commentary. With that, let's go over to our Opioid Task Force bill referral. There's a little background to this one. Corey, would you kind of walk the committee through this? What took place?
Mr. Chairman, the Opioid Task Force met during this interim and reported to the Labor Health Committee at their last meeting. I believe that was in late September. This was one of the bills presented by the Opioid Task Force to Labor Health. It's 19 LSO 113, Crimes and Offenses, Controlled Substances. The Labor Health Committee reviewed it, debated, I understand, for maybe a half hour to 45 minutes, and decided that this was more in the purview of the Judiciary Committee. They requested that Management Council refer it to the Judiciary Committee. Management Council, in fact, did refer it to the Judiciary Committee and left it to the Judiciary Committee's discretion as to what to do with the bill. I'll walk you through the bill. It essentially does two things. First, it amends the current statute 62108, drug-induced homicide. Currently, this statute penalizes a drug delivery that results in the death of a child. The amendment to this provision essentially removes Romanet 1, which dealt with the perpetrator being an adult or at least 4 years older than the victim. Romanet 2, this is line 6 on page 2, strikes the victim being a minor and inserts a person. So the effect of that is if a drug delivery results in the death of any person, regardless of that person's age, it is a crime under the amended statute. The second thing that the bill does is it expands the crime of endangering the welfare of a child through exposure to controlled substances. Currently, 6-4-405, endangering children controlled substances, is specifically targeted towards endangering a child through exposure to methamphetamine. The proposed amendments to the bill would expand that by striking the reference to methamphetamine and expanding it to any controlled substance. And I should just jump ahead to subsection E, which is on page 3, lines 19 to 22. As used in this bill, controlled substance means any controlled substance that is a Schedule 1 or a Schedule 2 substance. So it actually isn't any controlled substances. And it specifically exempts marijuana from that list. So going back to the actual amendments, page 2, line 17 and 18, it adds the word unlawful to the absorption or otherwise causing a person to, or excuse me, a child to unlawfully absorb, inhale, otherwise ingest any amount of controlled substance. Page 2, lines 21 and 22 is a similar prohibition, but this one makes it a crime to allow a child to stay in a room, dwelling, or vehicle where the person knows that a controlled substance is unlawfully being manufactured or sold. Page 3, lines 1 through 5, Romanet 3. Essentially does the same thing, expands it from methamphetamines to controlled substances where they're being manufactured or stored, or the hazardous waste from the manufacture of a controlled substance exists. Page 3, line 10, again, replaces methamphetamine with controlled substance being unlawfully possessed, stored, or ingested. And parenthetically, I should note that the report from the Labor Committee indicated that this might have been a cause of concern, that this was a rather broad provision, that a person having the care, custody, and child shall knowingly or willfully permit a child to remain in a room, dwelling, or vehicle. So essentially, if you have a child in the house where they know that a controlled substance is unlawfully possessed, stored, or ingested. So part of that concern, if I just elaborate on what I've learned from the report from the Labor Committee, is that now that the controlled substance has been defined as a Schedule 1 or 2 substance, there are some substances that can be prescribed and possessed legally under prescription and housed in a house with a child. But if that substance were possessed unlawfully, that same substance were possessed unlawfully, just having a child in the house would make that person a felon. I think that's part of the reason why Labor Health referred it to this committee. Further down on page 3, lines 13 through 17, subsection D, it makes clear that this section doesn't apply when the substance is being administered by a practitioner lawfully, either by the parent or the practitioner under a prescription or the direction of a practitioner. And we've already touched on E, defining controlled substance. And I believe I already mentioned this, but 62108A Romanet 1 is repealed, and that's the paragraph that defined who could commit the drug delivery resulting in death. With that, I'd stand for any questions. I would note that there are a couple of the non-legislative members of the Opioid Task Force here, Dr. Harris, Dr. Merrill, I believe, and I'm not sure if there's anybody else, but they might be able to speak to some of the pharmacological aspects of the controlled substance issues.
Tori, before we go too much farther, seems like there was talk about this would apply to prescription drugs if their date of use expires, and would that then mean that if you had them in the house and there were children in the house and you had expired scripts, that it creates that situation?
That was a concern, and I think I'll leave the doctor of pharmacy to address that. My understanding after speaking to her is that that would not make the possession unlawful. That's an expiration date on the medication itself. But that's my current understanding, that would not make the possession unlawful. That's not necessarily I think that's an open question legally, but that I don't have a firm answer for you. But I don't believe that having an expired prescription would make it the possession unlawful.
I guess part of it was the reference about the Opioid Task Force and the opioid, problem surging in the U.S. And so, all right. Questions for that explanation? Again, keep in mind, this just came to us from Management Council. As we go through the discussion, recognizing it's the third meeting, this is the first time we've seen this. There was not a a clear message from the Management Council. We want this heard and delivered to the floor of the session. We would just like it referred to the committee, and then it is completely up to this committee. There's no arm twisting going on or anything of the sort. So with that, Representative Stitt.
Mr. Chairman, thank you. I have a question that's closely related to your question for LSO staff. On page 3, when at line 15 and 16, when you have the carve out for a parent pursuant to a lawfully obtained prescription, and if you can walk me through an example of that, using, for example, if you have a mother who has a 10-year-old and a 12-year-old, 12-year-old has asthma, 10-year-old has a sore throat, 12-year-old has a prescription for albuterol, the 10-year-old has a prescription for cough syrup with codeine. But their symptoms flip and mom decides to give them both products. As this is drafted, would that make the parent, in violation of the statute?
Or if it's a sister or a brother.
So if I understand your question, having controlled substance lawfully in your possession, but you make a mistake in the administration to which child you give it.
Or intentionally. Either way. Presume it's intentional.
And again, I think that would come up to the discretion of the prosecutor's office, seeing how that case would come. But I think the argument that there could be an argument made that violates the section.
Okay. Yes, Representative Salazar.
Mr. Chairman, couple comments since it was brought to Judiciary. First of all, I want to commend the task force. We are facing an opioid epidemic nationally, but I know it's hitting home in my district personally. I've gotten calls. I'll give you an anecdotal 30 seconds. Husband and wife. The wife has been on painkillers. It's now a substance abuse issue, and there's 2 kids under the age of 5. Something has to be done. And I think I know the origins of the beginning of this task force and who brought it forward, and I totally support it. I don't know of any, as of right now, I don't know of anything else dealing with the opioid issue other than this bill. But it's affecting thousands of Wyomingites, and I don't know if this is the spear or the avenue that we should look at first, but it has to be addressed. And the scenario with regard to this bill of children being harmed is a real issue, and I would encourage this joint committee to seriously look at this issue, because as of right now, this is the only bill that I know of before the state legislature that's dealing with the opioid epidemic. And again, I thank the task force for their work.
Okay. Any other comments of staff at this moment, or questions of staff? All right, with that, let's go ahead and open it up to state agencies, town, county, prosecutors, judges. I mean, the judges are always welcome and always invited to speak as we work through our issues. Where's Mr. Odekoven? There you are. He always.
Since that's my cue.
I anticipate you have something to say on behalf of the chiefs and sheriffs.
Thank you, Mr. Chairman. Byron Odekoven, Executive Director for the Sheriffs and Chiefs. I was present at the Opioid Task Force meeting. They took a very serious look at a number of issues. Representative Salazar is correct that the task force did some good work trying to flesh out how Wyoming could be responsive to several of the issues. It was not initially thought that child endangerment was necessarily the first thing that would come out of the task force discussion. It became clear over time that the act of endangering a child while you're doing some of these opioid style addictive behaviors is very real and very serious. And thus, our statute is somewhat weak as it exists now for a child being in the presence of that dangerous activity and how best to proceed and prosecute. The paragraph that you are wrestling with, D and E, is the first attempt to say, yeah, but we aren't meaning if you're doing things legal that you're somehow then could be mysteriously charged with something nefarious in terms of endangering your children. If you're doing it legal, then that's not endangering. It's if you're doing it illegally that is dangerous. So, Mr. Chairman, we would rise in support of the bill to help in defining those kinds of activities. You may or may not wish to tweak a little of that language to make it clear that lawful activity is lawful and illegal activity that endangers children is clearly not tolerated.
Questions of Mr. Odakoven? Yes, Representative Winters.
Thank you, Mr. Chairman and Mr. Odakoven. So just based on the conversation that you were able to witness there, then on page number 3, where it specifically exempts one substance from what is considered a Schedule I drug, what was some of the conversation that surrounded that? And what are your thoughts and feelings on that?
Mr. Odakoven?
Mr. Chairman, let me answer, rephrase the question ever so slightly for clarity as I answer. So the controlled substance that they're looking to designate as being endangering children is anything that is Schedule I. Schedule I does not have any medical use, by the federal scheduling of. So Schedule II may have some of those same style drugs, but have specific medical use. So Schedule I and then, or Schedule II, but it specifically defines which Schedule II drugs. So they were trying to narrow that to those kinds of drugs.
Senator Hicks.
So to pick up where my colleague left off, I think that the question is, so if we go back and we read the provisions under 64405, which is endangering children, and then we go into subsection A, it says no person shall knowingly and willfully cause or permit a child to absorb, inhale, ingest a controlled substance. If we go to subsection E, it exempts marijuana out of there. So the way the bill reads now is if you're an adult and you want to smoke marijuana and you got an infant child there, you could certainly have them inhale all the marijuana they want. And that's not a crime anymore. So it starts down the road to decriminalizing marijuana. So for members of the task force, I'm curious as where we jump from opioids to decriminalizing marijuana. Further, if we go in and read the definition of WS 37102 that we're exempting out, it's not just the leafy form of marijuana, it is the manufacturer. So let's take this and walk it through again. So the next section talks about remain in a room, dwelling, or vehicle where a person knows or controls substances unlawfully being manufactured. And so this committee has worked on this issue of extraction of THC and the potency of that for the last 3 years. You could actually have a child in somebody's house that was extracting THC or manufacturing hash, and exposing that child to those drugs is no longer a crime. So that provision to me is I just have to understand why, when we're talking about child endangerment, when we look at the definition of marijuana and we're exempting that out, what was the thought process there? Because quite frankly, I don't understand why we would expose children to inhaling marijuana or manufacture of hash or extraction of THCs and levels and resins, and at the point that we know as a committee, based on the testimony that we have, we can extract down a vial now that is enough THC to kill a herd of elephants. This would allow that to happen in the presence of a child. So I'm really confused as the support of the Sheriff's Chiefs Association with that provision in there. So if you can enlighten me, I would very much appreciate it.
No additional comments. We'll stand with your first statement if you support it.
Thank you, Mr. Chairman, and I failed to remember my note. When they first looked at it during the first meeting, the limitation discussion was opioids. It was somewhat of a surprise to us to see in the final version that they added marijuana as an exemption to the discussion, and you're exactly right. The manufacture, the extraction of the oils involves some chemical processes. Colorado at the moment is having some homes exploding, doing all kinds of things that are going on with some of the extraction processes as it relates to marijuana. So you are correct. Our support would end or would be to the Schedule 1 discussion and not to the exemption discussion of the marijuana manufacturing style portion. So I apologize and thank you for reminding me of where I was supposed to stop in my support comment.
Representative Winters.
Thank you, Mr. Chairman. I want to express my appreciation to Senator Hicks. I tried to gently caress the 800-pound gorilla. He stomped all over his feet. Anyway, I just appreciate that.
Thank you.
Mr. Chairman.
Representative Pelka.
Mr. Odakoven, since we've been embroiled in the whole process of criminal justice reform, I'm just curious what you think the impact might be on our judicial and correction systems if we prosecuted parents under this provision, if we prosecuted for simply smoking marijuana in the presence of children.
Mr. Chairman, I think
Yes.
that would be a better question of a prosecutor for whether or not they would prosecute for those kinds of activities based on the statute. I would withhold trying to sort that out on behalf of them.
Okay. All right. Anything else for a rep from the chiefs and sheriffs? Okay. Mr. Pelkey, was your invitation to the Ms. Trent to see about that question in your own community? He set you up. Welcome.
Mr. Chairman, I think it's important for.
We're streaming, if you could. Okay. Mr. Riedel, if you could.
Mr. Chairman, I'm Matt Riedel, County Attorney in Sheridan. And just for the committee's information, there's another statute that comes into play here too, because there's a second child endangering statute. And that child endangering statute is 6-4-403. It prohibits among other things, knowingly furnishing a child any drug prohibited by law without a physician's prescription, general endangerment. It is charged in some jurisdictions within the state. The example that was given of parents smoking marijuana in front of a child, that is charged as a child endangerment offense. This offense carries 1 year and for a first offense as a potential penalty, and a second offense carries up to 5 years.
Any questions for Mr. Riedel relative to that part of this paragraph or anything else about the bill, if you're good with that?
Mr. Chairman.
Senator Hicks.
So, Mr. Chairman, under that statute 6-4, and I think you said 303.
403.
403. So once you have a citation or you don't have a citation, which one of those statutes are you going to choose from?
You could go either.
We exempted it out or go back to the child endangerment?
You could do either way. That would be a charging decision that the prosecutor could make. The prosecutor could take a look at the situation involved and exercise their discretion and pick one or the other.
But Follow on with Mr. Riedel. If you have two statutes in conflict of each other, how does that play out? If
I'm
one
not sure
exempts
that
the crime and the other one calls it a crime. Exempts the action, excuse me.
Right. Mr. Chairman, I think that that may limit you to the one statute that criminalizes the conduct. And I think that that would be the only effect that that would have.
The exception under this proposed language wouldn't likely be used then as a defense for a charge under the other statute? Not knowing I'm playing lawyer.
Let me find and which language, Mr. Chairman, which language are you referring to?
The one you talked about, endangering child, the 64301.
Right.
Or whatever it was.
403.
And then in contrast to line 22 on page 3, that exempts marijuana as not being endangering children.
I'm not a very good defense attorney, Mr. Chairman. And so there are other able counsel here that may be able to provide a theory under which that might be a viable defense. This is a definition of what constitutes a controlled substance under this section. It would be cleaner to clean that up because they're essentially, well, this is, I think arguably they are within the same section. So it would be, it might be possible for them to make, for the defense to make that kind of argument.
Representative Stiff.
Thank you, Mr. Chairman. I think it's, in some ways, it's kind of simple. The 403 statute is a misdemeanor statute. Lists all the things that of which you can be guilty of a misdemeanor. This proposed new statute which 405, which currently applies only to meth, right? If we adopt this draft bill, it would expand it to include not just meth, but all the controlled substances. So it would just mean that if you were under a marijuana exemption, if we left the language as is, it just wouldn't be a 5-year felony, right? It might still be a misdemeanor under 403. It's just all about meeting the elements.
Or on your second offense under 403, it's a 5-year?
I don't think so.
I don't know.
That may be.
Senator Nethercutt, help me here.
If I were to speak now, Mr. Chairman, I would probably redirect the conversation.
You're welcome to do that.
Thank you, Mr. Chairman. If I may, Mr. Riedel, this question to you since you're sitting in front of us. Do you believe that this bill will help deal with the challenges that many in our communities face regarding opioid addiction and solving that problem?
I think it will, it may not solve necessarily the problem of the user, but their children, yes. I think it may persuade some parents or alert them to the idea that they shouldn't have that type of substance present. Much the same way that I think some people have been persuaded that they shouldn't have methamphetamine in their home. So to that extent, I think it may.
Do you believe it would have a deterrent effect, Mr. Chairman, if I may?
Yes.
Okay. Any other questions for Mr. Riedel? Thank you for joining us. I think we may have some other state agencies, but representative from the task force. Since you're all part, really the big part of this conversation, and probably should have got to you first. To give us a little bit of background as to the whole thing. And as you can see, there's interest in that last sentence on page 3, along with the rest of this.
Mr. Chairman, Committee, Dr. Melinda Carroll, Doctor of Pharmacy. I'm here to answer any of your questions about the pharmacy aspect of this, and then I will turn it over to
And your last name again?
Carol.
Carol.
And my name is Dr. Allie Harris. I'm the State Health Officer at the Wyoming Department of Health, also on the Opioid Task Force. Also happy to answer any questions about the public health aspects of this. These changes were brought up by the Attorney General's representative on the task force, and we did discuss this on the task force. We believe that the marijuana discussion was related to cannabidiol or CBD oil, which can be legally prescribed to children with epilepsy, seizure disorders in the state, even though it is a Schedule I substance. Oh.
Sorry, cannabidiol, the Epidiolex that has been approved for use for epilepsy has actually been rescheduled to a Scheduled 5 medication now, which would exclude it entirely from this bill. I do believe that that was a miscommunication listing it as marijuana. It probably should be the cannabidiol that should be listed instead of marijuana.
Okay. Do we have that term? You have the right.
Yeah.
Okay.
In statute.
All right. Thank you. Other questions? Yes, Representative Winters.
So, Mr. Chairman, just for my clarification, so are you saying that if we struck those three words, the use of Epidiolex or cannabis, that word would be would still be, we could still use that because it's now classified as Schedule 5. Is that right?
Statute covers more than that, doesn't it?
Mr. Chairman, Senator or Representative, excuse me. If we were to remove, I believe that if you would strike just marijuana and list cannabidiol instead, that would clear up the matter. There are other drugs that are in process of being studied that it is unknown whether they will be listed as a Schedule 5, a Schedule 2. So this particular medication that is the only one on the market currently that's approved has been rescheduled to a Schedule 5. Okay. There are other CBD oils that parents have used that are not FDA approved currently, that can be obtained in Colorado, that if that parent were to be found in possession of that, we would not want that parent to suffer the consequences of this particular bill.
Mr. Chairman.
Representative Salazar.
Thank you, Mr. Chairman. I have three quick questions. Number one, what is the status of the task force now? Will it be ongoing or taking a look at the opioid issues in Wyoming, or are you done? My second question is, at least in some constituent concerns from my district, the whole issue of prescribed drugs for people who go doctor shopping, and they have these prescriptions legally. They just misuse it when they are long over when it was originally intended to be prescribed. Thus, with small children in the home, you have a catch-22 here, where you have a legally prescribed drug. Small kids, they shouldn't be using it, but they're addicted to it. And then finally, I guess it's more a comment than anything. This is really an important issue, and I would like to see this bill go forward. People, at least in my district, people are looking for immediate help in this opioid epidemic. And other than this task force, I don't see where the state legislature is moving forward to address the issue of the opioid crisis in the state of Wyoming. So, thank you, Mr. Chairman.
Mr. Chairman.
Is that a question? All right.
Chairman. Representative Salazar, in regards to your first question, the status of the opioid task force, yes, we are continuing for one more year. There are 3 bills that the Labor Committee is also considering they have agreed to sponsor, and one is being considered on Tuesday when they meet. And in terms of the doctor shopping, and so them having legal prescriptions that could be accessible to the children, yes, I agree that this bill doesn't address that, and that is a large concern. In fact, most of the overdoses among children, according to public health data, are actually because of prescription drugs and not the illegal drugs. There are public health campaigns out there teaching parents how to safely store these medications, and there is some indication that there may be a decrease in these overdoses since those campaigns came out. But yes, this bill does not address that.
Okay. Other questions? When we started this conversation early on, we talked a little bit about expired prescriptions, and then the language on page 3 on line 15, by a parent pursuant to a lawfully obtained prescription. And I'm not familiar with the current law, or if this is new law or new definitions, but does that exclude uncle, aunt, grandparent, brother, sister from, and is that the law today, from giving a prescription to a sibling?
Mr. Chairman, in reference to the scenario that was given, if that prescription was given to the other child and that resulted in a death, yes, I believe it would be covered under this law, because on every prescription, it is stated that this prescription is only intended for the use of the person it was prescribed to. Therefore, if it was prescribed to the 12-year-old, given to the 10-year-old, it did result in a death, yes, that would be covered under this. And I'm sure that that would be a prosecutor's discretion on whether they would charge that way or not.
On this page, I don't think it's talking about the first paragraph on a death or that kind of thing. It's just talking about administering. And it looks like the only people that can administer are a parent or a practitioner. And that was, I guess, my question. And is that current law today? I mean, if a grandparent gives the child their prescription at bedtime, under current law, are they committing a crime? Or would this language, is that the intent of paragraph D on page 3?
Mr. Chairman, I see what you were pointing to now. It would not be unlawful for a grandparent or a uncle, aunt, whatever, to administer that if they are in guardianship of that child at that time, if they are the care provider. I do not believe that that was the intent of this, to have it exclude those caregivers to just a parent. And I do think that moving forward that probably should state caregiver instead of parent.
Okay. Any other questions, these folks that have generously helped with their time and remain committed? Thank you.
Mr. Chairman, one quick thing I wanted to address on the expired medications. That is correct. If that bottle has an expiration date on it, that expiration date is given just so that the patient knows when their medication might not be as effective or might not be a good thing to take. It does not mean that that prescription expired for the patient to use. It just means that they, for health reasons, should probably not take the medication.
Mr. Chairman.
Senator Hicks.
Can I ask a question to expand that concept? So a lot of times on those prescriptions, it'll say take 2 pills twice a day with food, has an expiration date on there. So it's pretty easy to track back is if the patient hasn't been taking their prescriptions. And so I'm just curious, under that scenario where you have these available, so they haven't been taking them and they may have had several bottles of these sitting around in that particular case, would it still be the case then that it just identifies that it may not be viable after a certain period of time? There's kind of it's a nuanced scenario there, but it's a little you know, if we ran into a scenario where those were in the house and in the possession, other than just it's no longer viable because it's expired versus somebody that has not been taking their medication and stockpiling that stuff.
Mr. Chairman,
Please.
Senator Hicks, in that particular scenario, I would believe that there probably should be other investigations at play. If you maybe have a doctor shopper or you have a person that is distributing rather than using the medication, those would be the instances that I could see that happening in. You know, there's probably been several of us that have been prescribed, you know, a pain medication after a dental procedure. Maybe we didn't use that all and it got left in our medicine cabinet for 2, 3, 4 years. That would not be an unlawful possession of that at that point. The scenario that you gave, like I said, I believe further investigation would need to occur into why they had so much of that on hand and what they were doing with the medication. Again, I would say that that would show that maybe they were distributing the medication instead of using it.
Okay. Anyone else? Thank you very much. Appreciate that. Is there any other state agencies, county, city government that would like to address? Come on up.
Good morning, Mr. Chairman, rest of the committee.
Afternoon.
My name is Lisa Hunt. I'm the Executive Director of the Board of Pharmacy. I stand for questions. I have information about laws that the legislature has passed since 2003 on the WORKS prescription, the Wyoming Online Prescription Drug Database, and any other questions anybody has. I have information about federal law prohibiting the transferring a prescription drug to another person it's not prescribed to. Any questions?
Do you have any answers to any of the questions we've kind of rattled around here today, or things you think we may be missing?
Yes, Mr. Chairman, members of the committee. So per the question that was asked about the parent giving the medication to a different child, since the parent or caregiver would not be a licensed or authorized prescriber or practitioner, that would be unlawful. It's also unlawful by federal law. I looked up on my phone a commonly used prescription label that's put on your prescription bottle, but it keeps going blank. So I would have passed it around, but I didn't foresee your question on that. The other question dealing with the CBD oil, the legislature passed extensive requirements in order for that to be lawful. Those state requirements, if all of those criteria are met, means that the CBD oil would at that point then be legal and they would not be charged for possession. So
For the Schedule 5?
Even in Schedule 5. The CBD oil right now is not scheduled in this state. It's actually, it would be a Schedule 1, except that the legislature put in language that as long as all of the criteria are met under that statute, it can be legal. They have to have a card. They have to make sure that the CBD oil has a certificate of analysis that shows the THC content is less than 0.3%. There's a lot of criteria that have to be met in order for that to be lawful. And then it was as stated earlier, it's the Dravet syndrome or severe epileptic disorders that are covered. So.
All right. Questions? Questions, Ms. Hunt? All right. Thank you very much.
Thank you.
Any other comment? Yes, Director.
Good afternoon, Mr. Chairman, members of the committee. I'm Bob Lampert, Director of the Department of Corrections. As the potential recipient of new potentially five-year felons, I just want to remind the committee that basically what this is doing is criminalizing the collateral consequences of illegal behavior. So in order, as I understand it, in order to qualify for prosecution under this proposed legislation, somebody has to commit illegal behavior. And I do understand the desire to protect children, but I believe the current child endangerment statutes already provide that protection. So I just wanted to make that comment. Thank you.
Questions, Director Lampert? Okay.
Mr. Chairman.
Hold on. Representative Stiff.
Mr. Chairman, thank you. Director Lampert, along the lines of what you just mentioned, is there any data about their drug-induced homicide statutes on balance save lives or cost lives? And the scenario I'm thinking of is you have 4 people all doing opioids of some kind. One of them stops breathing. And the question is, do you dial 911? Do you take them to the hospital, or do you walk away? And so is there any data for states that have, really strict, strong induced, drug-induced homicide laws, if that's results in more deaths or fewer deaths?
Mr. Chairman, I don't have that information.
Okay. All right. Anything else? Thank you. All right. Before we go to the public, anybody else from the agencies? Public comment. Any public comment on this one? Come on up, Mr. Jewin.
Mr. Chairman, my name is Tom Jubin. I'm not here on behalf of any particular organization with respect to this bill, but I thought I would just give the committee a little bit of information based upon what I'm reading to assist it in digesting what this bill might do. I would draw your attention to page 3, lines 7 through 11. That paragraph says that no person having the care or custody of a child shall knowingly and willfully permit the child to remain in a room, dwelling, or vehicle where that person knows that a controlled substance is unlawfully being possessed, stored, or ingested. As the committee knows, this particular statute initially addressed methamphetamine, which was known to have significant health concerns for anyone who was in the proximity of it. When I saw the marijuana exception, I thought I understood why it might be there, but apparently I was wrong. Note that this doesn't merely involve situations where we're talking about what Senator Hicks was referring to on breathing vapors or that sort of thing. This talks about storage. So theoretically, if a parent has Uncle Phil come over and Uncle Phil has a bad back and he takes marijuana gummies to treat his back, and you know he does, and you know he's got them with him, and he comes to your house and your child is in your house, you just committed a felony. So you may want to consider that issue in figuring out how to deal with that particular provision of the statute. Just
any
Mr.
questions?
Chairman?
Yes,
Could you run
Senator.
through your hypothetical scenario again? I want to understand, because here's the operative point of this says is having care or custody of the child. What if it's not your responsibility to have care or custody?
Mr. Chairman, Senator Hicks, I'm not sure where you're going with your inquiry, but let's assume for a moment it's a parent and they have their child at home, and Uncle Phil comes to visit, and Uncle Phil always has his marijuana gummies or whatever with him, and you know he's got them. If you allow your child to remain in that dwelling while Uncle Phil's there with those things, you've committed an offense. If you're Uncle Phil, you haven't violated this because you don't have care, custody, or control of the child. Theoretically, yeah. If Uncle Phil's babysitting, maybe he does, and maybe then he has committed a felony.
That was thank you, Mr. Chairman. That's what I was trying to get at. Is the parents are the ones now that have committed the crime, not Uncle Phil. Bill, Uncle Leland, whoever.
Yes. Okay, thank you. Thank you, Juven. All right. Any other public comment? Any other public comment? Sure, come back up, ma'am.
Mr. Chairman, Dr. Melinda Carroll, just one additional statement in regards to what it states having these substances on the premises. Methamphetamine, as we know, can have very serious health effects. So can some of these substances that are in these bills. Fentanyl in a very small portion can kill a child. Same with oxycodone, same with hydrocodone. So I think that we're talking about the same type of harm to the children. It's not that, you know, that we are trying to over legislate this. This would be considered the same severity as methamphetamine.
Okay, thank you. Representative Stith.
Mr. Chairman, thank you. Let's take the example of where you don't like the high cost of your high blood pressure medication. And so you go to Tijuana, Mexico, and you buy it there for much cheaper, and you bring it back home and you store it in your home and say it's your Lipitor that you got at half the price. And if your child's there in the house, then you're a felon under this, right? Because that's a controlled substance that you're illegally storing, right?
Mr.
You don't have a prescription because you're not allowed to import it from Tijuana, right?
Feel free to talk from your end of it. If we need to go with the prosecutors, we can always invite them back up.
All right, Mr. Chairman, Representative Stith. So Lipitor is actually a scheduled drug, or a legend drug, not a scheduled drug. So if Lipitor was found in your possession that you purchased from Tijuana, then no, you wouldn't be, that would not hold you to this. This is referencing into controlled substances under the C1 and C2 classifications, which I do have an extensive list. Most of them are opioids or stimulants such as amphetamine salts, methylphenidate are the stimulants. The opioids are much like we've been talking about, the fentanyl, the oxycodone, hydrocodone, those type of things. All of those things would be something that would endanger a child. As you're saying, if they did go to Tijuana and purchased oxycodone or Percocet, yes, it would be, you know, child endangerment under this act. And yes, that would be a dangerous drug for that child if they were to ingest it.
That's all right. Okay. Yes, Senator Anton.
Thank you, Mr. Chairman. So I guess just for me, when I'm trying to decide how to go with this bill, basically what I'm hearing you saying is that it's probably beneficial to change from methamphetamine to controlled substance, because we do know that fentanyl is very, very dangerous. If it's touched, even you see that law responders have to carry the Narcolon or naloxone to remediate that. So I'm feeling pretty good about that. But my question then becomes, how about the marijuana and the marijuana products? Are those really dangerous? Should we just exclude the cannabinoid oils? And where would you direct us to go with that?
Mr. Chairman, Senator, that is a hotly debated topic right now. Marijuana can be dangerous to children. You know, I am of the opinion that you probably should not have that in your possession or take part of that in front of your children. However, the way that things have been going, I foresee marijuana is probably going to be on a fast track to legalization sometime soon. So I don't know if it would be prudent to exclude marijuana or not. I do think the cannabinoid oils need to be excluded in this. Marijuana is still a Schedule I drug, not recognized with any medical usefulness federally. So, I mean, I would stick to the federal law. I practice based on federal law.
Mr. Chair.
Representative Winters.
Thank you, Mr. Chairman. So, ma'am, do you think then it might be a good idea if we kind of refine that down to where Wyoming law and statute currently is? It's 35-7-1901 Romanet 2, but it describes there very clearly hemp extracts and actually defines it out regarding the cannabidiol oils and in those different substances. So if we were to essentially just change that a little bit to bring it into conformity with current statute, might that be something that would bring this into line with what we're needing?
Mr. Chairman,
Please.
Representative, I do believe that that would alleviate some of the concern over this particular portion of the bill, and it would be prudent to match up the two. So.
Anything else? Thank you very much. Okay.
Mr. Chairman.
Hold on. Who would you like to talk to?
Well, I'm going to ask for volunteers.
Oh, okay.
Anybody? So what I'm grappling with here is under the currently existing child endangerment statutes of 64403. Is there something in there that we couldn't prosecute under that statute already? Or are we just creating more statutes to prosecute the same crime? So anybody that would like to take a stab at that question, because I think that will determine the way I go on the bill.
Mr. Chairman.
Mr. Riedel, would you mind? Ms. Trent?
We got a volunteer.
Yep. I guess I'd refine the question a little bit to say we heard that initially the first occasion was a misdemeanor, second occasion was a 5-year. Is there a level that could take that up to a felony on the first occasion?
Peggy Trent, Albany County and Prosecuting Attorney's Office. To clarify, as noted earlier by Mr. Riedel, there is currently a child abandoning and endangering statute. We currently in Albany County prosecute under this statute for those situations involving marijuana, other drugs, and in there specifically, it does indicate furnish. Hold on, just I'm going to read it to you. It says, of course, I've lost it. Sell, give, otherwise furnish a child any drug prohibited by law without a physician's prescription. And so we currently prosecute under this. However, it's a misdemeanor. So when we have, and when we do it in Albany County, if I have methamphetamine, I will prosecute on the more specific statute. And the reason I understood the rationale behind the methamphetamine prohibition is the effects in the manufacturing and distribution of methamphetamine. I think, personally, I would recommend amending the methamphetamine to just include, and Mr. Riedel and I were back there discussing opioids, and that's it. Leave it at that for now. We prosecute. I'm not seeing this, and what my concern is, every case that's going to come across my desk now will include by the officers, because I do the charging documents and affidavit of PCs, the officers are going to be requesting me to charge this additional charge now, in addition to whatever they may have to track on. I am not a person that believes that we need to overcharge. I believe we charge what it is and we prosecute for the crime that's being indicated. So quite frankly, I respect and understand where we're moving with the crisis. We need to do something. I would agree with Representative Salazar. Something needs to happen. We need to move. I think it does send a direction, but I will tell you, drug dealers don't read your statutes. They have drug abuses, substance abuses. I think if we're moving on our next item of discussion of criminal justice reform, I think Director Lampert is kind of right in where we're going. We need to focus on treatment. We need to focus, and I believe that the current laws are in place right now that we are using it. Would I like to see an increase in penalty for that under that specific section in 64403? Yes, but I always want increased penalties. So at this point, that's what I would say to you. If we want to take it serious in our state and we take an approach on opioids, why not just add that and not do controlled substance to be expansive to everything? And I respect, I understand. As a matter of fact, I just did a training today on this very issue to our school district. And part of it was going over this specific statute with our teachers so that they understood what they're seeing and they don't to know the different drugs. So
is your suggestion to add opioids or replace methamphetamine?
I think you do both. And so meth or opioids, either one. And that way, that gives the prosecutor, if I have that available, and that's approach I'm taking, a hard approach in our community, that will send a message, I believe, and deterrence, like Mr. Riedel said. So that way we're putting that out. We're picking a different drug, and the effects of opioids and certain things, if we touch it, we were just talking about fentanyl and different things, that is highly dangerous to children. So I could see why that's in the same classification of meth. All drugs are dangerous to children, but we do have a statute to address it right now.
Any questions? Thank you. Senator Hicks, did that answer your question?
Absolutely.
Okay. All right. Let's going to close public comment, bring it back to the committee. Again, the question is, having seen this for the first time, are you comfortable with, I mean, if you'd like a motion, move forward, pretty straightforward. But again, this hasn't had near the time and the ability to gather more information that we've enjoyed on some of our other bills. So decision is up to the committee. Is there discussion or a motion?
Mr. Chairman, I motion to table for any further consideration.
Move to table. Okay. We've got a motion and a second to table this conversation or this suggested bill. Any discussion on the motion? All in favor?
Aye.
Say aye. Opposed?
No.
No.
Okay. That passes.
Passes.
The motion passes to table.
Okay.
Getting all wound up there.
Hey there, Senator. Just want to make sure that I'm
Okay.
awake.
All right, folks, it is just a bit after 3. We're going to jump into justice reinvestment. Let's take 5 minutes and we'll roll again in 5 minutes. So if you need a quick break or a stretch,
We're actually changing plans. We're not going to be presenting today. Just another meeting. So we're going to be returning to the audience.
You looked at your agenda.
I'll explain when we get back.
CSG update on the data analysis. Marc was give us that. I think what we're going to do in respect for all those who have traveled and cut their day moves like this, we're going to go ahead and instead move to a brief overview of the bills from LSO. And then we will work our list of speakers, starting with Director Lambert. And he'll come up and we'll invite him to give input on each one of those listed Justice Reinvestment bills. The committee will keep notes. And then we'll just go down our list like that. And hopefully we'll be able to get to everybody and still have some time for some public comment. If we are done before 5 o'clock, we'll invite CSG to pick up. Otherwise, CSG will be doing their part in the morning. But out of respect for all of you who put your calendar to be here with us, it's a little different than how we've usually done it. The intent then tomorrow is to take the notes, your input, and the committee then to move into the bill working portion of the process. And so this is the time this afternoon to give input on each item. And as you move through, before we leave that item, something critical pops up, you want to make sure you get it in there, but we still got some good ground to cover and a little different, but we thank you for being here. It's just the end of the year, the last meeting, and we wanted to give every bill the best shot of gathering information we can. So with that, let's start off with Director Lambert. And again, what your committee has in front of them, just so you understand what you're doing, start writing, is we have each bill on its own sheet, place to take notes, who comments are from, then we'll factor that in tomorrow into the committee deliberations. So, Director Lambert, take us away, and let's just start out with crime victim compensation, eligibility.
Mr. Chairman.
Whoops. And the LSO introduction first. I'm sorry.
No problem. LSO, our different attorneys will introduce the bills briefly, and each legislator on the committee has just a kind of a note sheet. So, Kayla.
Mr. Chairman, my name is Kayla Spencer. I'm one of the staff attorneys with the Legislative Service Office. I'll be presenting 19 LSO 221 Working Draft .5 entitled Crime Victim Compensation Eligibility Clarification. At the September meeting, based on the recommendation of the Council of State Governments, the committee directed the Legislative Service Office to work with Mrs. Chambers to expand the statutory benefits for crime victims' compensation to 36 months. This bill clarifies the timeframe for benefits will be 24 months from the date of the injury or the discovery of the crime. It expands the benefits for mental health care and counseling to 36 months and conforms Section E, which relates to additional amounts available in the event that there's a catastrophic injury. Looking at the bill directly, the amendments start on page 2, lines 4 through 10. That's the biggest change. This is in subsection D of the statute, and that just relates to ordinary compensation under the program. Lines 4 through 6, the bill specifies the compensation timeframe as 24 months from the date of the injury or the discovery of the crime. Those two dates are in there is it gives the division some flexibility if an injury is found out to be the result of a crime at a later date. The next part of this is still page 2, lines 7 through 10. This is where it allows the division to extend compensation for mental health counseling and care up to that 36-month time frame. The next one is still on page 2, line number 19. We've just changed losses and expenses to economic losses. That comports with the language used in D, and that takes advantage of a defined term in the statutes. The final amendment on the bill is page 2, line 20. It just adds the date of discovery of the crime so that that matches the language in subsection D, where the compensation starts either on the date of the injury or the date of the discovery of the crime. And I'm certainly available for questions. Ms. Chambers also would be available for questions on this bill draft.
Mr. Chairman, not specific to the bill draft. Where does the funding come from for the crime victim compensation?
Mr. Chairman, I would have to defer to Mrs. Chambers for the answer to that question.
Good afternoon, Kara Chambers, Division of Victim Services within the Attorney General's Office. There are two sources of funding for crime victims compensation. One source is federal, it's the VOCA compensation funds, and the other source is through our surcharge funding, which comes from criminal fines and fees.
Mr. Chambers, if we enact this legislation,
Sure. I know you nodded, but Chairman, through you, Senator Hicks. So one important thing about this change is it doesn't increase the amount of compensation available to a victim. It merely increases the amount of time that they can access it, which, sure, by virtue would mean that they could come closer to the cap if they were to do so. In fact, Kayla and I did some quick math. We actually internally cap mental health. We pay for the initial session in full, which is usually under $200, and then we pay $85 per hour after that. So if you consider $15,000 over 3 years, you'd have to, what did we decide? You'd have to go once a week for 3 years, which is a lot. The fund is actually very sound. I make a terrible joke often that in this business of surcharge, crime does pay because it pays us and we pay victims. So the fund is very sound.
Okay.
Sadly, very sound.
Thank you.
Yes.
All right, next one.
Mr. Chairman, the next bill draft, 19 LSO 231, the limitation on the length of probation. To be brief, Mr. Chairman, this bill draft would limit the maximum term of probation for felonies to 42 months. That would include any extensions or modifications would still be subject to that 42-month cap. The bill draft would apply only to persons sentenced or placed on probation for deferred judgment on or after the effective date of this act, which is July 1st, 2019.
Questions on this? On this one?
Mr. Chairman.
Yes, Representative Pelka.
Thank you, Mr. Chairman. I'm curious right now what your average numbers are and how many times you exceed a 42-month limit.
Director.
Mr. Chairman, I believe in Mr. Pelka's presentation, he has the actual averages for that. Off the top of my head, I don't want to guess.
Okay. Mr. Pelka, can you just give us that number from? You can come up a little ways. The mic picks us up.
Thank you. It's 60%. Marc Pelka, Council State Governments, Deputy Director of State Initiatives. 60% of felony probation terms are longer than 3 years at the start of supervision. 40%. So yeah, 11% are within 2 years. 30% are within 3 years. So that leaves the remainder of the terms are 60%, 3 years or longer.
Okay. Thank you. Thank you. All right. Any other questions for staff on this one? Please continue.
Next bill is 19 LSO 227, limitation on length of parole. The committee directed LSO to draft a bill that put a cap on the length of parole at 30 months. We amended 713-201, maximum and minimum terms. Currently, the statute requires the courts to fix an indeterminate sentence, but requires them to set a minimum and a maximum sentence. The maximum sentence must be within the statutory maximum. The minimum sentence must be at least the minimum if there is a minimum mandatory. And further, the minimum may not exceed 90% of the maximum term. This bill changes the scheme. Page 2, lines 7 through 14, it replicates the existing statute but puts it into paragraph form. Page 2, lines 16 through 20 includes new language that the maximum term shall not exceed the minimum term, and then gives two options, and I'll explain the two options. The first option is by 30 months if the maximum allowable sentence is less than 25 years, and B is by 60 months if the maximum is 25 years or more. We were trying to do the 90% math, and in order to keep the 90% minimum true to the existing statute, we felt that we had to put those two options in. It's applicable to persons that are sentenced on or after the effective date.
Okay. Questions?
Mr. Chairman.
Senator Hicks?
Tori, could you just go over an explanation of section 2 on the bill? Some level of retroactive. Just clarify why we need section 2.
Well, people that are already sentenced, it would be an ex post facto law. So we can't change the sentence of existing sentences. The committee can certainly change that to make these provisions applicable to any person who commits a crime after the effective date. That would delay any prospective savings by a year or so. If we did it that way, we felt that ex post facto was preserved or avoided by using sentenced on or after the effective date.
Thank you.
Okay. All right. Thank you.
Next bill is 19 LSO 217, modification of probation. The committee directed LSO to draft a bill that did two things. Number one, clarified that a court may sentence to either supervised or unsupervised probation. There was some perhaps conflicting language as noted in the staff comment for page 4 and 5. And these alterations make clear that supervised or unsupervised are options. The second thing that the bill does is provides standards for determining the length or modifying the period of probation. And to accomplish that, starting with page 2, 713-305, determination, continuance, or extension, revocation of proceedings. We've added language that the court determining the period or modification of probation may consider. And then the following page and a half, Romanettes 1 through 8, list a series of factors that the court should consider, may consider in determining the length of probation. They include employment, community support, familiar responsibilities, substance abuse issues and treatment and progress. And it specifically indicates that the relapse alone does not prevent the court from determining that the defendant has made progress on substance abuse issues. Nature of the crime, risk posed to the defendant, to the community, and the risk of reoffense as determined by a validated risk assessment tool. Again, the other two modifications just clarify that a court can grant either supervised or unsupervised probation.
Questions? Thank you.
Mr. Chairman, the last bill draft is 19 LSO 230, probation, parole incentives, and sanctions. This bill draft is based on the committee's direction at the last meeting to work with CSG to draft a bill that would address the policy options that were listed on the CSG summary in point 5 that focused on the use of an incentives and sanctions system and requiring the use of short-term custodial sanctions before proceeding to revocation. CSG provided language for this bill draft, and we've taken that as the base for the bill. Mr. Chairman, with your permission, I'll broadly describe the bill and defer a line-by-line consideration until tomorrow. Mr. Chairman, this bill draft would require the Department of Corrections to establish an administrative incentives and sanctions system to use for those who commit compliance violations of their probation, parole, or conditional release. The bill draft defines a compliance violation as any violation except for a new felony and deliberately absconding from supervision. The bill draft would provide a list of authorized sanctions, which would include community service, the loss or restriction of privileges, placement in an intensive supervision program, jail sanctions, which could be a 2 to 3 day quick dip or a period up to 15 days, 90 days in a residential community correction program, jail or prison with treatment attached to that 90-day period. Mr. Chairman, the draft also would cap the maximum length of the shorter quick dip custodial sanctions. The bill draft also provides a procedure for the department to follow in terms of holding a hearing before when receiving information of an alleged compliance violation and whether a hearing is necessary. It provides for certain situations where a hearing would not be necessary, including consent or if part of an intensive supervision program. And Mr. Chairman, with that, I think that broadly describes the bill. There is a separate memo attached to this bill, which I'll briefly mention now. It is policy of separation of powers, particularly when thinking about what this bill draft does to probation. Mr. Chairman, I'm happy to go further into detail on that or wait until tomorrow at the committee's preference.
Let's, tomorrow will work. All right. And with that, back to the Department of Corrections on crime victim compensation. And if there are any of these that you don't feel compelled to speak on them unless there's an issue that you want us to be considering on each bill. Thank you. Representative Winters.
Mr. Chairman, so would we have opportunity to ask questions today or tomorrow on like for instance that last bill? Just one question.
Today would be the day. Tomorrow, co-chair is going to be managing the meeting tomorrow, and I haven't asked him of this idea, but I would think tomorrow, if the committee has additional questions as they're working the bill, and if there's someone in the room that might have some input, might honor a request from the committee clarify. But the intent tomorrow is not general discussion. We're trying to gather that tonight from interested parties, and then the committee works the bills tomorrow.
Very good.
But for today, if you have brief questions or don't feel worried that there won't be a chance to discuss it as a committee tomorrow, inquire.
Very good. Thank you.
Yes.
Mr. Chairman, just a real quick question on the last bill that was just discussed. I was wondering, in some of these may be forthcoming, but is there any fiscal note at this particular point, or will that be coming at a later time?
Later time.
Thank you.
Okay. Representative Pinnell.
Mr. Chairman, just a quick question on the line drop through here, but I assume that states in there on the county jails that are funded, that they're still planning to paying county jails out of the state.
Yes. Representative Jennings.
I just have one lengthy question. on page 14, on line 9, there's a paragraph A,
Which bill are you referring to?
the last bill that we were talking about
Last
there.
bill?
I just, for a little personal edification here, it seems like a contradiction in that the court may impose at any time modify any condition of probation or suspension of sentence. And then it says the court may not impose new custodial restrictions on liberty. So could we get an example of what that might look like?
Yes, Brian?
Mr. Chairman, I'll try to answer that question. This was part of the language provided by CSG, so I'm not sure if Mr. Pelka would have further comment, but I think the intent behind the language and the staff comment alludes to this would be that the court could not impose a new custodial restriction, meaning some sort of sanction on a person's liberty.
Representative Jennings.
Chairman, the beginning of this paragraph is at any time modify.
Your microphone turned on?
Yeah, I think so. At the beginning of the paragraph,
Page 14, is that where you're at?
page 14, line 9, it says that they may at any time modify any condition or probation or suspension. Well, suspension would be a restriction on liberty, I would think. It seems like it's like the paragraph is contradictory.
Brian?
Mr. Chairman, Representative Jennings, I believe the intent here was the court could modify any condition of probation, but I think with the added language, the court could not modify a condition of probation that would somehow impose a new custodial restriction. Custodial restriction, I would take to mean some sort of incarceration or order to comply with, some sort of residential program or something of that nature.
Good. All right.
Mr. Chairman, members of the committee, Bob Lampert, Director of the Department of Corrections. Here at the table with me is Steve Lindley, Deputy Director. Really quickly, I would ask for consideration at the end of Mr. Pelka's testimony tomorrow to have a few minutes to provide a summary as well, not specific to the individual statutes proposed, but just to the overall process. So if I could ask for that. In terms of the bill drafts, Bill Draft 221, which was crime victim compensation, we have no concerns with that bill. Next draft is 231, limitation on length of probation. I have no notes. Steve, do you have any?
Mr. Chairman, I think the LSO staff explained it well. There may be further discussion on, as was alluded to a bit ago, on average length of probation terms served. The genesis of the idea of capping probation terms is derived from the large percentage of violations that take place in the first 3 years, with the overriding goal being allowing probation and parole agents to focus on high risk, high need people. And this is one strategy to direct that, their time.
Yep. Okay.
Okay, Mr. Chairman, in regards to 2227, which is the limitation on length of parole, my read through of this as drafted, I'm a little concerned that it could actually serve as a disincentive to parole, and that inmates may opt to jam their sentences rather than go out on parole, for 3 years before their maximum is the way that I'm reading it. So the other approach to making this happen in terms of limiting the length of parole is through some form of earned discharge from parole, without limiting the maximum length of the sentence. So that's just my comments on that. Steve?
And Mr. Chairman, this one I think is a bit more difficult than the probation cap. So the probation term is determined by the distance between the minimum and maximum sentence, allowing for good time. There's inmate good time, and there's also parole good time. The discussion around having something equivalent to that in the form of probation caps and or earned time on probation would make them a bit more equitable in that regard. So I'm sure you'll hear from the director of the Board of Parole who's here, and the judiciary may have comments on that portion as well. But that one's more complicated, clearly. If you have someone on a 10 to 30-year sentence, they could be on parole for quite a long time. They can get parole at the 10-year mark, forget the good time conversation right now, and then they're on parole for the distance of that. And so in long-term sentences like that, this becomes a little more challenging, I think. And so I would be interested in hearing from some of the other stakeholders on how they view that. We do know we have a decent, in my view, inmate good time system in place and a parole good time system in place, which there's not really a version of that for probationers. So anyway, I think it'll generate some discussion, and I'm not confident it's right where it needs to be.
Mr. Chairman, Bill Draft 217, which is modification of probation. My only note is in regards to Romanets 1 through 4 on page 3 of some of the list of the things that can be considered for modification. Those are, in my opinion, those are things that are captured under number 4. Those are all criminogenic risk factors that are assessed as part of the assessment process. So I'm not sure that they need to be separately considered. And that's my only comment. Steve?
Okay. And Mr. Chairman, I'm also trying to paint the larger picture that gave rise to the discussion. So with the goal being, if people are doing well, being able to move them through their probation term, complete their conditions, and move them off. This is another effort to do that. The judiciary and prosecutors, I'm sure, will speak to it. There have been some challenges in accomplishing that there are a couple of statutes currently that allow for it. There's a rule of criminal procedure that speaks to modification of sentences that may conflict with it, though the statute, to my understanding, would take precedence over that. But not every judge views that the same way in discussions with them. So in the end, that is the goal, is to try and be able to allow people who are meeting their conditions, have successfully met their conditions, to move through probation and off before the term expires, as set by the court. And these are some criteria to do that.
All right.
Finally, Mr. Chairman, with regard to, excuse me, draft 0230, my comments are fairly brief. I think Steve had a far more detailed analysis than I did, and I apologize for that, but I'm just returning from a 3-week vacation where I didn't pay attention to anything. So, and that would be on page 6, Romanet 3, the 15 consecutive days. I believe there's other statute that currently has 30 days, 30 consecutive days. And then finally on page 7, Romanet 6, the 90 days. In our previous draft request to have this additional sanction available to us, we had 180 days. I'm a little concerned that a 90-day return to prison may not give us the time to address the substance abuse issues that need to be addressed in that time frame, particularly around methamphetamine. So the 180 days gives additional flexibility to the agency as well as to the courts. Steve?
Okay.
Mr. Chairman, again, the overriding intent of this legislation is to build a better intermediate sanction continuum for the probation and parole staff to use with people that they're supervising. Again, going back to the fact that 50% now of the prison intakes are probation and parole failures. What are some strategies the state can implement to safely change that? We're now trying to set a goal of reducing that by 25% over a 5-year period. In other words, to move 250 or basically 125 to 150 of those people into other strategies that don't jeopardize public safety and that increase their likelihood of actually succeeding. So there are some, as the director pointed out, the 15-day citation on page 6, lines 13 through 15 is potentially problematic. It might conflict with a couple of other statutes. So that might need reworked a little bit. And as the director pointed out, on page 7, beginning on 12, line 12, this is an idea we had promoted last year as well that fell out, I think largely because of cost of it. Anyway, the idea of returning to a Department of Corrections facility for drug treatment, essentially remaining under the authority of the court for probationers, back to probation. So, Mr. Chairman, there will be some of those kinds of problematic, I guess, pieces in there that will need some discussion, but in the end, that's the overall intent of this legislation, of this piece of legislation.
Okay, thank you.
And Mr. Chairman, I was unclear if I will have the opportunity at the conclusion of Mr. Pelka's testimony tomorrow to provide a summary from the agency perspective. Okay, then that concludes our input.
Okay.
Thank you.
Yes, Senator.
Just real quickly, thank you, Mr. Chairman. Mr. Lindley, could you just restate what you stated? I just want to make sure I heard it correctly regarding the goal for the next 5 years.
You're on 230, right?
Oh,
Yes,
Mr. Chairman and Senator Nethercott, one goal is to reduce the recidivism rate by 25%. So it has increased in the last 4 years, roughly. We would like to return it to the level it was 4 to 5 years ago, when at that point it was the second best in the country. These are all strategies in order to do that. Toward the end of the latter part of 230, number 230, there are references. Some of that needs, I think there are a couple of citation errors in there, but quickly it talks about, for intensive supervision, only allowing high-risk people in there. The science is pretty clear. Focus on high-risk people with criminogenic needs. That's where systems need to put their efforts and resources. Low-risk people largely will get through successfully without too many interventions, and in fact, too many interventions will increase their likelihood that they won't get through. And then there's that conversation around the adult community corrections centers as to what should be the population that they're serving as well, moving toward potentially a classified medium to high or higher risk person. Those, of course, are controlled by local statutorily authorized boards that determine who gets in, and so that's another conversation. But all of that's in this piece of legislation.
Mr. Chairman, if I can add something. When Mr. Lindley said reduce recidivism by 25%, that that may be a goal, but from my perspective, a clearer version of that is to return the overall recidivism rate to below 25%, which is where we were before, but specifically to reduce the rate of revocations by 25%, because more than 50% of our population driver is from probation and parole revocations. So if we can reduce that by 25%, I believe that, coupled with the other suggestions contained in this legislation, we will return to under 25% total recidivism.
Mr. Chairman.
Thank you.
Thank you, Mr. Chairman.
Yes, Representative Pelka.
Thank you. Earlier in your comments, you spoke about the need to expand that 90-day period to possibly up to 100 days to address underlying substance abuse issues. Would it, instead of that, would it be helpful if we included an option to mandate inpatient treatment, for example?
Director.
Mr. Chairman, the statement that I made was our original request was for a sanction of up to 180 days, and that's because of the length of time that it takes to successfully impact specifically methamphetamine. But that's a top end. Under the draft legislation that we had proposed, that 180 days is subject to completion of the treatment as prescribed, and then we go back to the court at any period during that 180 days. So that 180 day would just give us additional time frame to address all forms of substance abuse.
Mr. Chairman, thank you. So in essence, you've got that option now, is to.
Mr. Chairman, we do not at the current time.
Okay. I mean, under your proposed legislation, you would have the option of mandating treatment, for example. What I'm afraid of is that the quality of treatment in jails and prisons in this state isn't up to the level of an inpatient treatment.
And Director, Mr. Chairman, I'd respectfully push back in that I believe that we have quality treatment within our institutions. The problem is that when you mandate treatment for a person under supervision, if you don't mandate the quality of treatment that the person's going to, then you get across the board. That's what we're running into now, is that people who are referred to treatment are forum shopping for the easiest and quickest way, and it's not being successful. Through the sanction process, we're saying that we can guarantee the quality of the service that's retained if we do it in-house.
Okay.
Thank you.
Thank you.
And Mr. Chairman, just with all the work that's gone into this, and we just myself quickly rushed through and tried to summarize, there's a lot of material in there that will require a fair amount of in-depth conversation, and from the people in the audience and input there. I was doing a very quick summation of what that particular piece is striving to achieve, but there's a lot of detail in there that will require some concentrated look at it, because some may need changed or tweaked or potentially taken out or adjusted. So anyway, I feel like I didn't do that justice.
Oh, we're a little bit up against it, but we're working with what we have, and there will of course be many more opportunities should these bills move forward to refine and educate and discuss as we get into the session. Okay.
Thank you, Mr. Chairman.
All right. Thank you very much. Diane Lozano, State Public Defender's Office. Should I say Diane?
No, I am not Diane. Mr. Chairman,
I'm just reading my script.
members of the committee, I'm Ryan Roden, the Deputy State Public Defender, and State Public Defender Diane Lozano couldn't be here. So she directed me to let you know, though, that we support all of the bills, and we believe the legislative steps are in the right direction for the right reasons, and that's all we have.
Wow. Any probing questions?
Mr. Chairman, we can't let him off the hook that easily. So
we'll make it good.
So I'm So the question I have for you, we have an LSO memo here, and I believe it's the last bill that we have. It says that we may be encroaching on the executive branch of government's authority. So I'm assuming that that blanket statement that you support the legislature encroaching on the executive branch of government's authority.
Sure, yes.
Good.
Thanks.
Thank
Mr. Chairman. Mr. Chairman.
Just a second, hold on. Senator Kinski.
Just thank you. I just wanted to make sure that we took a run at this once before and it fell apart because there was not confidence that the resources in the community were there in order for these folks that were being put into these programs to succeed. Have you seen an influx of resources and supports that you feel comfortable that your clients are not just being consigned to a path of failure, but that there's going to be the resources in the community that they can actually succeed under these programs if they're diverted from prison?
Mr. Chairman, Senator, I don't have that information, across the state, so I'm not sure. I've been part of what's been going on. I went to the symposium that was in June, and talking about beds and funding and that still exists out there. So we still have waiting periods on getting into treatments. But if they're out, what I'm hearing that, those that are successful, they're out there waiting for the beds and we keep checking for them and then we're getting them in as fast as we can when the beds are available. So we do believe in everything that's been put forward that this is the right step, that we can go forward with what we have. It's better than not going forward. So we believe it will work.
Follow up.
Give me a kind of a range of a waiting period, high to low for the bed.
Anywhere from 3 months to 9 months. We have some people waiting that long.
Okay. Well, that's worrisome, Mr. Chairman, because I thought the whole essence of this to work, it had to be swift. Things had to move quickly.
We haven't got to the additional resources part of the conversation.
Yeah. Thank you.
You're welcome.
Be depending on appropriations. All right. Thank you very much.
Thank you.
All right. From the prosecutors, Ms. Trent. Come on up. Thank you, Mr. Riedel, for being here with us also today. And we'll just work through the list again as we did.
Okay.
Starting with crime victim compensation, eligibility, clarification.
Mr. Chairman, first of all, as you know, I am Peggy Trent from Albany County, but I'm representing today as the newly elected president for the Wyoming County and Prosecuting Attorneys Association. And I'd like to take a moment to thank you for allowing us this opportunity to talk. And as you see, I brought Mr. Riedel in tow here today. But we wanted to kind of give you some exciting news, just so as we preface this in our comments. We have been working hard as an association, and I heard this committee loud and clear the last time I was present in Laramie about the need that we have representation at these meetings and having dialogue and education as we move forward. As a result of that, we have been working hard to bring about a state prosecutor coordinator, and you'll be hearing more about that in the upcoming legislative session and about the need. We are the only state, I understand, in the United States that does not have that, where we have that relationship where we're basically bringing all the prosecutors together, just like you see with the Sheriff's Association and county commissioners, in order that we can give you a position and also get some continuity statewide in our association, educating our prosecutors and getting uniformity. I think that also helps with the criminal justice reform as we become more organized in how we're approaching sentences and structure. So I wanted to put that out there to this committee today, that is part of the process. So hence, Mr. Riedel has volunteered to start assuming that role, so to speak. And I wanted you to know that we have surveyed and spoken as much as we can with all of the county prosecuting DAs, not the newly elected ones. I think we have a total of 6 coming in, but we have talked to, as best as we can, kind of put all those comments to all bills today. And I was going to have Mr. Riedel address those comments, kind of give you the thoughts of our association, if I may.
Thank you. Mr. Chair,
I could begin by indicating too that part of this coordination that we're talking about is giving prosecutors the opportunity, the ability to actually get some research done on some of the research that underlies these legislative enactments. And for instance, in this particular case, contacted the National Association of Prosecutor Coordinators, and we asked them for information about the 31 states that have capped the 31 states, thanks, the 31 states that have capped probation and how that's worked out. We've been receiving information about that. That's part of our due diligence that we're doing on the legislation. With respect to the first bill that you mentioned, the crime victims compensation, we've been trying to talk to our colleagues about all of the legislation. What we have at this point is not even really a representative sample. It's less than half of the current elected prosecutors, but we wanted to be here. We didn't want to be left at the gate. We wanted to be here and tell you what it is that we're doing, and that we want to continue this dialogue between prosecutors and the legislature about our perspectives. So what I can tell you is that with respect to the crime victims compensation bill, there was a misunderstanding. Basically, everybody supports it. Everybody supports that bill. There was some confusion in some quarters. Some people were reading the bill to create a period during which coverage had to be ordered. And the period, they were confusing the 24 months as being when an order had to be entered within 24 months of either the injury or the economic loss being discovered, or I forget what the other trigger was. But that's not what the legislation says. That's been corrected. The confusion is taken care of. Do you want to move to the next, please?
Yep.
On the limitation of probation to a term of 42 months, I reached out to Marc Pelka, who was kind enough to provide me with information regarding the research and the data that underlay these proposals. And he identified that there are 19 states that have enacted earned discharge policies which enable people on supervision to be discharged prior to their sentence and end date if they comply with supervision conditions and do not commit major violations and are not assessed as being at high risk of reoffending, among other factors. He also identified that 31 states have enacted the cap on felony probation terms. I need to correct that first statement because Wyoming actually does have, it's a fairly simple process, but we do have a system of earned discharge policies. And it's found in a statute that is cited later on in the materials. It's 713-305B. Now, in the draft that you have currently, it stops at 305A. And there are a number of subsections after A, essentially standards for probation. I'm assuming that since B and C and D have not been crossed out, that the normal convention would apply. And so the intent is not to drop B, because B is actually our earned discharge provision. It says upon a period of probation A says a period of probation or suspension of sentence under 713-302 shall be determined by the court and may be continued or extended. B then goes on to say, as currently written, upon the satisfactory fulfillment of the conditions of suspension of sentence, that would be what's commonly referred to as a 713-301 or comparable sentence, or probation under 713-302, the court shall, mandatory language, enter an order discharging the defendant. Now, the way that that works in my shop is that we typically, we've told probation and parole in my jurisdiction that we'd like to see probationers at least do half of the term of probation before they bring something before us, because we feel like that's what's actually needed to see some change affected. And so if they've got somebody that's been performing well on probation, they're at the halfway point, they send us over a petition for expungement and an order of, excuse me, a petition for discharge and an order of discharge. And typically we will sign off on that if we have a disagreement, or if we want more information about a particular individual, we follow up with them. That's our earned discharge currently. The concern that has been expressed by the current elected prosecutors with the 42 months is that they feel that it's not long enough. And the issue there, we know that there's nothing magical about 42 months. It could be 48 months. It could be 36 months. There's nothing really magical about that number in terms of any better degree of success necessarily for the probationer. There is one concern that I think may be valid with respect to the concern about length, and that is that we know that there are some drugs, for instance, methamphetamine. I remember from several years ago a study that came out that indicated that it took heavy users of methamphetamine, it could take them up to a year before their cognitive abilities would return to a position where they would be able to perform even the most basic of tasks that we expect of a probationer. That might be a situation where you might want to have some kind of extension. The other option that would be available would be to do a split sentence and place them into a county detention facility for up to a year, and then start them that way. I could see where in some cases that may be more than is actually necessary for a particular individual. With respect, one thing I want to bring to your attention is there were a couple of comments that we've received where people were talking about imposing 10-year periods of probation primarily on juvenile offenders. And I have to tell you that that was not universal, and that there was other people pointed out that there is research out there that overkill with juveniles in particular is counterproductive. On the limitation on parole bill.
Just a second, Senator Hicks.
Mr. Chairman, I do think it's important because there's a significant number of people here that weren't at our meeting at Laramie, and it was to talk about why the 48 months and where it come from, because I think it's important background, especially in light of those people. So based on the work that we saw from the consultants from the CSG is when we looked at the empirical evidence, it showed that once you, it is actually the break point that we saw was 36 months. And at 36 months, at that point in time, it really didn't make much difference how long the probation period was as far as the effect of recidivism. So the side of the equation that we're looking at is for a reallocation of those resources from DOC, whether it's substance abuse or treatment, rather than, or personnel time, is to work on the front end where we know that if we have interventions early within that first 2 months and extended it out to 3 years, that's where we saw a significant reduction of recidivism. So this comes back to really a policy decision in the legislative arena, because the alternative is to look at a $50 million expenditure for a prison and providing DOC the flexibility to reallocate their resources to front load the treatment and the oversight on that. Now, that being said, the data would have suggested that we would have used 36 months. Being the nature that we're in Wyoming, we're pretty darn conservative, you know. Maybe we need them on probation for 48 months. So that's just the background on that for the audience, that I think it's based on how effective we are and where we're going to allocate those financial and personnel resources. So that's just background information.
Okay. Mr. Chair, please, Senator Hicks. And if I get this wrong, Mark can correct me on this. I think that's correct. The numbers, as I understand it, work out so that you have essentially, let's see, 66, 84, 85% of the people that that fail at probation fail within those first 36 months. Yeah. And so, you know, and then it dwindles down significantly after that. It drops down, I think, in year 4 to 9%. And so that's, and frankly, that's consistent with my experience. If people are going to fail at probation, they do it early rather than late.
Phil, and so just to kind of key this up, Mr. Chairman,
Go ahead.
it gets to exactly what I think Director Lampert's point was. Is the point is to get to this first 2 years of recidivism and start to reduce that. That gets to the long-term prison population. So, but that's just background for those people that didn't have the opportunity as to why we're even contemplating this. Is data-driven. Okay.
Mr. Chairman, if I may elaborate on that one point, some of the concerns with the limitation, I guess taking a step back, and I understand a lot of the prosecutors did not have the opportunity to hear the presentation nor the public and understanding. The concern is right now, how is that going to fix it by limiting the probation to 40, whatever number you pick, where I think you're going to still run into problems in all candor. And what we see in our juvenile system too is right now there's no decision matrix whatsoever implemented. So you're still going to have the variation, I feel, even on probation. When we get into these sanctions and administrators and regional, there's not going to still be that continuity. There's going to be a lot of discretion, and you can go up those sanctions rather quickly. And quite frankly, unless they're funded and you know their availability in your community and have a large tool chest, I don't see how it's going to help. So I'm taking, and I think some of the prosecutors, we've taken a step back. So get away from the numbers right now. The direction you're going, I'm not seeing, you know, I understand the assessments down the line. We're looking into those sanctions, which we'll get to in a moment, and the incentives. But the bottom line is you don't have a decision matrix. You don't have continuity that's going to have that throughout. That's why at the last meeting when I testified, I said, you kind of are moving towards sentencing guidelines without saying it, although we don't want to ever say we're moving towards sentencing guidelines. And so the question becomes, I agree. We need reform. We need to move in a direction. But I think what Mr. Riedel probably should touch upon when he reached out to our national counterparts, and I was amazed to hear when this was introduced, what we're getting right now, reinvestment and the reform and that, their responses and how they implemented it, and then it took a lot of fixes to get it to work. And I guess my concern by just moving in statewide without actually getting the buy-in and understanding those components, it concerns the prosecutors and me and everyone where you're moving in that direction. I guess I'm not seeing it as a probation. What we need is to front load treatment, front load pre-diversion programs, diverting, pre-trial release. Those are identifying those issues up front before you get to it. But I don't want to blow it up because I know this has been years in making. But the fact is, I don't see how realistically, regardless of what number you pick, how you're going to work through those sanctions and telling me that that's going to be the way to go. Further, you're tying our hands in a lot of way to the courts and the judges. And I think a lot of the prosecutors felt, what's wrong with what the judges are doing right now? And we don't even feel, no offense, probation parole, you have enough officers to even carry this out and do what's needed in switching the funds. So I'll go back to Matt.
And Mr. Chairman, there is a need, if we're going to do this and shorten the amount of time that is available for probation and for providing those services, we need to front end load the delivery of those services. We really can't afford, if we're going to do this, to have services that we recognize we need and not have them available when people need them. I know that there's a strategy in place where if there isn't some of those services available, that you go to the next highest level below that, and you start them off there. My understanding of the literature in the area of addictionology and those sorts of things would indicate to me that that's probably not the best alternative for the individual who's in need of those services. Typically, what they recommend now, they don't recommend 28-day programs. The only reason it was a 28-day program was that was what insurance would cover. It had nothing to do with anything magical about 28. And they recommend that if a person starts out needing intensive or needing inpatient, they started inpatient, they may leave before 28 days even and go to some lesser area category.
Comments? Questions? Senator Nethercutt.
Mr. Chairman, thank you. I just want to follow up with some additional clarity, perhaps for those that missed the meeting. And just to comment on the state coordinator position for the prosecutors, I look forward to that. I think it will provide a lot of clarity and provide a communication source, which I think is very, very important, as evidenced by today. To further add on to Senator Hicks, of that 48 months, much of that has to do with the empirical data that we received about our current inmate population in the Department of Corrections, which is costing the state significant sums of money. And that data suggests that those inmates may not be appropriately housed there as a result of too many probation revocations after that 36-month period. And that's why, and that's the problem that's seeking to solve. Not those probation revocations in that first 3 years that are significant substance abuse issues or offenders in other ways. It's the post 36-month offenders that are currently incarcerated in our prison population. And we're trying to reduce those numbers in order to save the state resources and then, of course, get those people back into law-abiding citizens in our communities.
Mr. Chairman, Senator Nethercutt. Yes, and that's the issue of the technical violations. And I understand that. I would quibble a little bit with what gets classified as a technical violation, for instance, because One of the things were substance use issues. This body, the legislature, passed a bill back in 2002, the Addicted Offender Accountability Act, because this body recognized that addiction is frequently a factor that leads or contributes to a lot of the antisocial conduct. And so I think that that's, I don't know that I would necessarily call that. We can figure that out, whether that's a primary issue, say, for instance, for somebody that was involved in an aggravated vehicular homicide or somebody like that, or whether or not this was something else. The other area I would quibble with slightly is absconding. There are different types of absconding. There's somebody that misses a court date. That happens. That's a technical violation. I don't think it's appropriate to, send somebody to prison for missing the court date. By the same token, we've also had, I've got one gentleman that we just finished dealing with who was on the lam for 10 years. That's an individual that basically was thumbing their nose at the rule of law. And they were charged with a felony offense. It was a serious felony offense. Fortunately for me, that individual made my argument for me because he got put out on bail and then took off again. And so when he got picked up, that was an easy argument to make. With respect to the sanctions and incentives, unless there were other questions, I don't think anybody really has a big problem with the idea of sanctions and incentives once you get past the issue of the memo that you received from LSO. I do think some of these strategies we utilize in our drug courts around the state, and they're recognized as having a positive effect on the people that have been placed in that system. The use, I don't think that there's really much of a concern there. There were several comments indicating that people did believe that probation and parole supervision should actually mean something. You can take that for whatever. I'm not sure I know what that meant. There was mention made in this connection with modification Rule 37 regarding whether or not the Supreme Court was the last word on modification or the statute. The Supreme Court, at least in their last comment on this topic, does not agree with the idea that Deputy Director Lindley offered, that the rule is subordinate to the statute. That's the general rule, but there are things about modification of probation and the status of probation that is different. And lastly, I would suggest that for purposes of transparency and keeping interested stakeholders together, that with respect to that particular piece of legislation, it wouldn't be a bad idea to consider having an advisory group to Department of Corrections on some of these things, and I'll tell you why. One of the things in there is reliance upon validated risk assessments. Validated risk assessments are very helpful, very useful. The Department of Corrections has one that they use in their pre-sentence investigation reports that go to the court. They chose the Compass assessment tool. There's a problem with the Compass assessment tool. There is what's called machine bias. It suffers from that. It doesn't have anything to do with some kind of intentional bias. It has to do with the data that goes in That's one problem with Compass program. The other problem with Compass is that the Compass algorithm is the manufacturers of that tool argue that their algorithm is a trade secret. That creates a problem, I think, from an ethical standpoint. They should not be able to sell a product that can have an impact on whether or not people stay in jail or are released from jail or go to prison, and not provide the information that tells us what questions are actually being asked and what the answers mean. And I would suggest that or commend that to your consideration.
Thank you.
And if you want more information about that, ProPublica did a story about Compass, and you can probably find it online.
Again, as should this go forward, there'll be more opportunities, and it'll be critical for your continued input, and I really appreciate your commitment. Thank you.
Thank you.
All right. Board of Parole. Kazi.
Mr. Chairman, members of the committee, first and foremost, let me introduce myself. Mike Kazi, the Executive Director of the Wyoming Board of Parole, and I apologize ahead of time for my voice, and I hope that I won't lose it before the end of the day. First and foremost, let me kind of echo the statements that were made by Ms. Trent. The board is greatly appreciative of the opportunity to come and visit with you to talk about very important issues, and in particular, this 5 bill drafts. And I'll try to keep my comments fairly brief. For the members of the committee, certainly we provided on November 5th, I guess what you could refer to as a white paper that essentially has some basic information regarding the probation and parole differences, as well as how the parole process generally works. And certainly, if anyone has any questions, by all means, let me know. But that gives you at least the general overview. And that information is also on our website, at least in terms of our board policies, as well as the reports that we publish there for everyone to see. The manner in which probation and parole is granted, as well as how it's revoked, essentially involves a lot of moving pieces. Much of the information that we obtain, or the board members obtain, and we obtain on their behalf, is really obtained from the Department of Corrections, which employs, of course, a lot of different types of staff. Inside the facilities, you have case managers, you have folks who have been involved in the rehabilitation of these particular offenders. Outside, you have probation and parole agents, as well as other folks who are, again, trying to make sure that they receive counseling and treatment and those sorts of things. So the board is constantly getting those sorts of pieces of information from those various folks. With regard to that, I think at any point in time, the board is in many ways dependent upon that information. And they're also in recognition of all the work that they do. We ask them, well, how many times, for example, has a particular parolee committed violations?
Are you speaking to any particular bill?
And I will in just one second, if I may. But the information that we get, again, comes from those agents. And some of the reaction that we'll have, and I think it'll be apparent once we start talking about the individual bills, why I bring that out. With regard to 217, I really don't have any sort of specific thing that the board has an opinion on, except there were some questions regarding unsupervised probation and how useful that is. But certainly that's much more for the judiciary to comment upon. Okay. We don't have anything to say about 221 or really 231. One thing that we will note with regard to 231 is it does have a similar issue to the length of parole bill, which is there doesn't seem to be a large distinguishment between types of crimes. So I don't know if that's something that the legislature intends or not, but certainly certain crimes can be punished by very lengthy sentences or no set sentence at all. And so you can have a lot of discrepancies or a lot of variation in those sorts of sentences, the issue you've already heard about from Ms. Trent and from others. Two bills that actually do have a fairly substantial impact on board operations, specifically starting with 227, the length of parole bill. As I indicated before with 231, there's a question about should there be some sort of a differentiation between types of crimes. We're really focusing on the length of a sentence. This body has certainly made its determinations with regard to how serious an offense is based on what sort of punishment you can receive. 227, it's got some interesting features to it. We do understand why it was drafted the way in which it was. If the bill had, for example, attempted to limit the amount of parole, you would have an argument that we are in fact discharging a sentence, which would create some sort of an issue with an executive branch agency overriding what the judiciary says. I don't know if Mr. Fuller's memo in any way addressed that. I gather it was about 230, so not 227. As it's currently drafted, you've got, again, the issue with is it going to present the opportunity or at least the concern that sentences won't be as varied as they need to be. So for example, if a court is asked to choose between sentencing high or low, are they going to go on a high range? That's something certainly the judiciary would have to answer, but the Board of Parole would have to deal with once it reaches that level. 230 is much more directly on point with regard to board operations. And my understanding, Mr. Chairman, is that we will actually go line by line on that. And certainly if we have the opportunity to present specific information regarding that bill, we'll do so at that time, if that's appropriate. Otherwise, I'll talk about just a few different points on it. 230 has a lot of things in it. It does a lot of different things. And specifically, let's point out, I guess on page, or one of the points that we'll talk about. Much of what's already talked about on pages 2, 3 of the incentive and sanctions system, that probably could be done not by statute, but rather by DOC operations, directing probation and parole agents in terms of how they're supposed to treat individual cases. Quite often what we see from the board, we do see revocation cases in which agents proceed, and it's only a last minute option. It is pursued only after they have done every other thing they really could. For example, when we look at this bill and it talks about things like compliance violations, it says a compliance violation essentially is a violation of a condition of parole. Well, one of the conditions of parole that's typically imposed is abide by the laws. This bill would, for example, as we read it, state that you are not going to actually revoke for compliance violations. You are instead going to sanction for those sorts of things. So just for the sake of argument, if we had a person who commits misdemeanors left and right, at least as one could interpret this bill, that would never lead to a revocation. They would simply be handled by sanctions. I don't think that that was the intent of the committee. I don't think that's anyone's intent, but we want to certainly clarify that.
Where's that at?
If you look at the definition of compliance violation is on page 15, lines 6 through 8. Actually 6 through 18, excuse me. Compliance violation means a violation of a condition of probation, parole, or conditional release, but shall not include, there's two things: an arrest for a felony offense under A, or B, absconding from supervision, which we've described essentially as deliberately making whereabouts unknown, or failing to report for the purposes of avoiding supervision, etc. Those two things are accepted, if you will. Those are not compliance violations, but everything else would be. So at least in terms of misdemeanors. So if you have an individual who constantly thumbs his or her nose at the process, who says, I only have a misdemeanor amount of marijuana, I've only committed a misdemeanor assault against whomever, those kinds of things, at least arguably, one interpretation would be they should not be revocation materials. And I, again, don't know if that was the intent of the legislature, but that certainly is one of the concerns that we noted. We believe that, yes, we do have to listen to those agents, and those agents do present cases that are usually well thought out. Another area of concern I'll kind of mention is with regard to the notion of having sanctions in general. The way the current process works, the Board of Parole can certainly be approached by agents, and specifically agents, their supervisors on up the chain, when agents believe that parole conditions need to be changed. Those changes can include adding programming. They can include specifying that certain folks are not supposed to be contacted. There's any number of things that agents can present to the board. The board looks at the information. They carefully examine everything that they've been given and make a determination of whether or not those conditions should be modified. We presently already have that process. Some agents pursue it much more frequently than others. Even in revocation cases, the matter does not necessarily go back to the Board of Parole. It can actually be stopped a little bit earlier by presenting it to us, the office staff, and we can look at ways of addressing concerns without submitting a person back to a facility. Modifications in that specific instance would be appropriate or may be appropriate. So we already have certain things in our policies and our procedures that address at least some of these issues. Wanted to bring that certainly to the committee's attention. And if there are specific questions, certainly let us know about those. With regard to, and I'll kind of try to end on this one, with regard to the question of good time and those sorts of things, we did address what good time, parole good time, and special good time are in our 3-page memo. And for those who don't understand that or don't know anything about it, which would make sense because most people aren't involved in that system, good time awards are up to basically 15 days a month for inmates. They are 20 days a month for parolees. And special good time is essentially something that can allow a person to reach their minimum number, go to parole a little bit early for certain limited purposes, among which is treatment. So if, for example, there is not a treatment program inside of a facility, there's at least the option of awarding special good time so that those folks can go outside of the facility and get that sort of treatment. That's just an example of how that might work. With regard to the language of this present bill, and specifically it's the amended 713-404, which is on pages 16 and 17. That suggests that we should automatically award any credit for any portion of time that the person has not violated a condition of parole. It's not quite clear what that means. Are we talking about a day-for-day thing? Are we talking about periods of time? How much credit are we talking about? The way that the board presently uses time is to address things like substance abuse issues. So for example, if we have an individual who needs treatment, but that treatment program is going to take 6 months, if you give them every little bit of time, including all the good time that they could arguably be entitled to, they would be out in 3. Treatment would not be successful in that circumstance because the person is not going to be on parole long enough to actually receive the treatment. So what the board presently does is they use those sorts of things, good time, other awards that they can grant, and they use that judiciously, or at least attempt to, in making sure that all of the parolees get the opportunity to go to treatment, that we listen to the agents and their recommendations, as well as stuff that we receive, again, from other DOC providers. So good time is an area where that certainly is very important for the board, because I think a lot of people don't understand how it is used. We do use it as a reward system, but it's also used to make sure that offenders are receiving the treatment that we are told that they need. And I will end, I guess, with one little point on that same page 16. There's the board shall consider imposing a sanction. That's on line 5. There was a suggestion that that should be may. Awarding, shall consider, don't really know what the full extent of that means, because it's not an automatic thing. If they have to consider it, great. But yeah, may just gives them a little bit of permissive language and allows them to use their discretion in terms of releasing folks or awarding good time and those sorts of things.
Any questions, Mr. Causey? Yes, Representative Stitt.
Mr. Chairman, thank you. Mr. Causey, thank you so much. Got a question about good time. Strikes me, I just want to get your thoughts. It strikes me as somewhat strange that if I'm an inmate, I'd prefer to be sentenced to 13 months of prison than to 11 and a half months of county jail. Because in prison I get good time and in the county jail I don't. Do you see any good policy reason to keep things that way?
That certainly, Mr. Chairman and Representative Stith, that's an interesting issue. That is one that we have noticed. I'm not aware of any policy other than the fact of I don't know how the disciplinary process works at every single jail. So are there discrepancies that one person might be able to identify at one facility versus another? That I cannot answer. That would probably be a question that the Department of Corrections should be able to provide information on.
Okay. Other questions? Thank you, sir. Thank you. All right. Is there, of our remaining scheduled speakers here, Mr. Jubin, Mr. Odakoven, Attorney General Michael, the judges, Judge Christensen, Judge Day, or Franz Fuchs, is there anybody that cannot be here tomorrow morning? Anybody that can't be here tomorrow morning? All right, then let's go ahead and go with one more, the trial attorneys. Tom Jubin, please.
Good late afternoon, Mr. Chairman. Tom Jubin on behalf of the Wyoming Trial Lawyers Association. Thank you for the opportunity to provide comments to try to improve the process if we can. I don't really know which one to start with, so I'll just pull one out. 231 is the bill which limits the length of probation to 42 months. The only comment I'd have is I wonder, and I don't know if this will occur, but I wonder if to some extent it might result in increase in the number of persons sentenced to prison rather than given probation. If the probation term is shorter, a judge might tend to think, well, since that's the most probation I can give this person, and they view probation as somewhat punitive, perhaps they would opt to send someone to prison. I don't know, but I know that probation has been defined by the federal courts as a significant restriction on liberty and in part punitive. So that's just a thought on that bill. The only other thing was there was discussion from members of the committee about 48 months and the bill says 42 months. I don't know if there was some prior draft that, or maybe I have the wrong draft. I don't know, but 42 months is what I have in front of me.
Yep. We've kind of thrown a bunch of numbers around, but the original number was 36 months, and it looks like we gave him an extra 6 months just because.
Okay.
Could come back to 36.
Because we're Wyoming, I think was that.
It might come back to 36 or
Mr.
24.
Chairman.
Who knows?
Mr. Chairman?
Yes, Senator.
If I can on that point, Tom, to answer your question of the longer sentences, that's something I think maybe you could help us with. Is there's 31 states that have already limited this, and maybe, before we get into the session, from a trial lawyer standpoint, or maybe we can get this from CSU as to whether we've actually seen in those states longer sentences as a result of decreased length of probation. I think it's a fair question, but I think the data's out there. It's just to go mine it. So maybe something you could help us with.
Mr. Chairman, Senator Hicks will certainly try.
Thank you.
Moving to 227, which is the limitation on the length of parole by altering the minimum term and the maximum term disparity. There was something in the handout in the policy detail that said restructuring the minimum and maximum sentence lengths is likely to have adverse effects on sentencing policy. It didn't say what those adverse effects are. I'm just curious, and perhaps you'll get that from somebody else down the road, but someone thinks it's likely to have adverse effects, but I'm curious as to what they might be.
Do we know where that came from? If you're here tomorrow morning to listen to their explanation, I'm sure they'll give it to us.
Okay.
Thank you.
Thank you, Mr. Chairman. The other thought that I had in reviewing this particular bill was it may be, and perhaps the judges could speak to this, it may be that a judge thinks, you know, if I give this guy who committed a pretty serious crime 25 to 40 years, that sounds like a more appropriate sentence than 25 to 30 years. I don't know. I don't know if that's the case. Maybe they'll say, okay, well, instead of 25 to 30, I'm going to say it's going to be 30 to 35 because that sounds better. I don't know, but it's just a thought that it may impact the way a judge views a particular sentence. I'm sure, I know the judges are very careful in what kind of sentences they impose. There's also the public perception, which may factor into it. Just a thought.
Thank you.
There's been talk about the validated risk assessment tool. I'm looking at Bill 217 or Working Draft 217. Mr. Riedel provided some information about that. I just had questions about who pays for that. It sounds like it's probably something that's done in-house by the Department of Corrections. It's supposed to be validated and objective. I think those things are good. Moving on to the long one, 230.
Okay.
On page 5, line 13, it notes non-residential community correctional programs established under a couple different statutes. Those statutes include non-governmental entities. I have always viewed with suspicion places that house people and incarcerate them that are not run by the government. There's a real disincentive for them when it comes to actually running the confinement conditions for people who judges say the state is imposing this on you and your liberty is taken away and you're going into the custody of the Department of Corrections. To have that farmed out is, in my view, a concern, but I can pontificate about that at another time. On page 6, there's a reference to a sanction of immediate confinement in a, quote, consenting Wyoming County jail. I know Representative Pownell might be interested in this one in particular because I think that means the sheriff has to consent. If they say, hey, I don't want these people in my jail, then that avenue may not be available in that particular county. Yet on the other hand, if you look at page 10, line 15, it makes the housing under this article, which is all of the 1800 series, mandatory. It says the sheriff shall house the probationers. So I just wonder if there's some sort of conflict in the language there between, on one hand, the sheriff being required to consent to use the county jail for these purposes, and on the other hand, the statute making it mandatory.
Brian.
Mr. Chairman, that information is highlighted in staff comments. The use of the word consenting on page 6, whether that conflicts with the language That would be on page 10 in the newly created subsection E.
Mr. Chairman, I'm happy to have been validated in that comment. Mr. Chairman, page 7, lines 21, 22, there's the use of the phrase conditional releasee. Maybe I missed it. Maybe it's defined somewhere, but I don't know what that means. So that might be word again. Conditional releasee. It lists that a defendant, probationer, parolee, or conditional releasee. And I'm not sure what that is. Maybe I missed it and it's defined somewhere, but or maybe it's somehow obvious to someone else, but it wasn't to me.
Mr. Lampert, do you know what a conditional releasee is?
Mr. Chairman, my recollection is it's defined in statute.
Perfect. Maybe it's in a place that's not in this bill, and I didn't go outside it. So
thank you.
Thank you, Mr. Chairman. There was a reference to constitutionality brought by the LSO staff, Mr. Chairman. On page 8, lines 9 and 10, it talks about having a hearing before a field services administrator and a designated hearing officer. I don't know, I haven't done the research, but the constitutionality of having someone other than a judge determine that somebody's liberty be taken away and they be confined may be an issue. On the other hand, I remember when we went through some similar legislation that was presented last year, there was discussion about consent, perhaps taking that away. I know if someone's standing in front of a judge and the judge says, well, I've got a choice here, you can accept these conditions of your probation, which means these sanctions can be imposed on you and it can be taken away by a hearing officer, but you have to consent to that. Or I can send you to prison. I can tell you that 100% of those folks are going to say, I consent. So maybe it's a non-issue, but maybe it is an issue. I don't know, something for the committee to consider. You can find the consent language on page 10, line 12. There's some language about the state essentially indemnifying the county if someone who is in a county jail pursuant to one of these limited revocations and incarcerations is doing time in the county jail. You know, there's a waiver of governmental immunity under 139-112 for peace officers. I think the jail folks are peace officers. I'm not really sure why that's in there. Something you may want to talk about and flesh out.
Where's that at again?
This is page 11, lines 30 through on to the next page. I mean, it is, after all, the sheriff's job to house people who are required to be housed there, and they're required to comply with constitutional requirements. So whether the state indemnifies or not is maybe an issue that Attorney General Michael will address, or someone from his office.
Okay.
On page 23, lines 11 through 14, there's definitions of incarceration and incarcerated. And then line 19 talks about incarcerated. As that section continues, if you look on page 24, line 14, it talks about imprisonment. It doesn't use the word incarcerated. I don't know if that's an intentional deviation from a previously defined term or not, but I just thought I'd point that out to assist whoever the drafter is.
Brian? We're good?
Mr. Chairman, real briefly on that, the amendments to those sections were just meant to conform statutory references that were being repealed and created here. That the word imprisonment on line 14 Mr. Jubin refers to was existing language.
Okay.
Mr. Chairman, while we're commenting on existing language, the indemnification is just a recreation of existing language in other parts of the statute as well. It probably is redundant.
Okay.
Okay.
Those are all the comments I have. If you have any questions, I'd be happy to try to address them.
We got any questions to shoot back at him? No. Senator Hicks first.
Mr. Chairman, I'm curious on this whole issue of the immunity, given the nature of when, if these people are incarcerated and we bring them back in the county sheriff level, this is probably more of a question for staff, is in many cases, we have service providers that aren't employees of either the county, and it could be for drug abuse or other. Are they indemnified if something happens while they're under service provider in the county jail? Particularly when we get with substance abuse treatment and mental health and some of these issues.
Mr. Chairman, Senator Hicks, and I think that may be addressed by the Attorney General's office as well. But I think that it's going to depend on the agreements that are made between the substance abuse treatment people that come into the facility and what that says. Most of those are probably going to require that they carry insurance on their own and they're not indemnified by the state. But that's going to depend on that agreement.
Okay. All right. Representative Stiff.
Mr. Chairman, thank you. Mr. Jubin, question, you talked about constitutionality on page 10, lines 6 and 7. It is a repeat actually of existing law, but it provides that the impositions of sanctions shall not require a hearing if the probationer or parolee is a participant in the intensive supervision program. And my question to you is that's something I've really not quite ever understood. Do you have an opinion about whether that's constitutional?
I don't, Mr. Chairman, Representative Stiff, I don't feel without doing significant research that I can give you a good opinion.
Any other questions? Any other questions at this point? Thank you, Mr. Jubin.
Thank you, Mr. Chairman.
And, will you be able to join us for a bit tomorrow?
I certainly can if you would like.
The only reason is to go back, and as we work through some of these issues, as we talked with my co-chair, if members of the committee are still trying to sort out some of these comments they've noted, if there's someone here, that'd be great, or we can always rely on the prosecutors to cover your bases.
I appreciate the invitation, Mr. Chairman.
You consent. Whatever you can do. We appreciate your time.
Thank you.
Thank you. Well, ladies and gentlemen, we are after the 5 o'clock hour. It has been a good and a busy and filled day. A lot of information. We'll pick this up in the morning with Mr. Odakoven and go through the rest of those and then some public comment before we bring the bills to the committee. Thank you so much for spending this long day with us and participating. We certainly didn't get everything answered, but we'll do our best to flesh that out tomorrow and then in the coming days, the session. So. We'll see you at 8:30.